Hi, good afternoon, everyone.
Good afternoon.
Thanks for coming. Hi. Thanks for coming for today's course. So, welcome. Thanks for your spending your time for today's course. And today we sacrifice our time here. Actually, want to learn something regarding to the law, something regarding to our investment. So we must be put more attention later on. So no matter how, since this is the first time we all meet each other, so I know that you're the attendance here. Attendance have been signed, so just be relaxed. Don't be too pressure. You just like take yourself like learning something. Something is more common things in your life. Then you just like a sponge to absorb something that maybe I can provide to you. You try to absorb it as much as possible. At least in future you can avoid something mistake or avoid something that is favorable to you. Then at least you can be better in future for the investment and the property in terms of the law aspect. Okay. So before we starting our course, just pay some reminder to you to say that you have to pay the parking fees. Okay, you make sure that you have been paying your parking fees. Because this area, a lot of summons are going to be issued, especially at this moment. Maybe 1 hour from now, they will come over for checking, for the parking. So today, our topic is regarding to the invisible hand behind the property competition. Why there's a 2.0? Because there is a version, definitely there's a version of the 1.0, right? So there's a 3.0 also. But the issue is that it means I separate my cases into the slot by version 1.0 to 2.0 and the 3.0 in order to easy for us to convey our message, to convey our course to the potential students. But the invisible hand means what? Initially, invisible hand means something that you can't see, but they did exist. They did make something for you to start yourself in the property transaction. So before we start our course, I'm Dr. James Ma. Then this is my handout. Then I will pass some handout to you all. Then at least you can go through it along all the courses that I've been conducted. Then make sure that you are with me all the times. Thank you. Before I know each other, better for me to recommend myself to you all. So before we started all the courses, at least I let you know that you put the silent mode on your phone. Then no recorder, no sound recorder and video recording in this classroom. Then just enjoy yourself for along all the course. Make sure that your phone won't be ringing and then disturbing all the others. I'm Dr. James Ma. Before I know you all, you know me first. I'm Dr. James Ma. I've been I'm a practicing lawyer for over 20 over years. I've been handling a lot of the civil and criminal cases as well in terms of these litigation matters. Along all the practicing years, actually, I did handling a lot of this challenging legal dispute matter, whereby certain things you found that they actually can be solved out of court settlement, but sometimes due to the face value, certain people they want to fight until the end. So you sacrifice a lot of times and the money, go to the pay the legal fees or other things, then until finally you end up your matters in the court. This is the problems. So the lawyer actually we provide the problem solving. So the problem solving always we put the court as a last resort. It means everything we can be settled, try to settle on table. Don't push it to the court because it's very costly in terms of the time and money. In terms of money. Legally, I did apply the legal theory to the real world cases. It means theory without the practical cases look like very void and meaningless. So important thing is that you have to link the legal theory to the legal practice. Then you can see that the actual world, when you apply the legal theory, is completely different. It's completely different from what you have been learning from the book. So make sure all the while we are more prefer the practical theory. Practical theory, the real scenario that did happen and bring the court case to in the real world, fight in the court. And then this is the cases whereby I've been compiled and try to show to you all what has happened in this, what's the rationale behind this, the legal theory. Meanwhile, I did think about it because all these cases is handled by me before in the previous year. Then I try to make it more accessible to you all, make it more easier and be more friendly to you all, to easily to learn and touch the legal aspect of the law. So the important thing is that to get you easily understand and apply it. Why? Because certain thing, if you know it very well, you know the sound mind, you have the sound mind to know the sound reasoning, sound judgment behind the legal theory. It means that certain thing you'll be avoided. Because if you bring the matter to the court, there's not something funny. It will cost you a lot of money, it will cost you a lot of energy, it will cost you a lot of time. So if you can avoid it, the litigation is better to avoid it. Always remember, put the court as a last resort. Don't fight it unless you got something good lah. At least you got something good lah. At least you found that you have something in hand. Or otherwise, to my advice is that try to solve it out of the court battle. Less cost. Okay, this is my background. I've been graduate in the Bachelor of the Business Administration, BBA with honors in 1997 from the University of Udara, Malaysia. It means that before I studied the law, actually I've been learning this BBA for 3 years. And then after BBA, I was working in the Saint-Dabi for 3 years or so to be the marketing executive for selling the heavy machinery for 3 years. That's why this is my background. So all the while, the business and the law, I can merge each other. It means that normally I've been better to fight the cases by involving more of the commercial aspect. At the same year, actually, I've been graduate. Not say graduate, it's a commission as a second lieutenant, the ranking from the this is official training unit, so-called the ROTU. It means that during the year of my undergraduate in the university, I did join the ROTU also for training. So this helped me in terms of the discipline myself, in terms of the how to put my aim, to pursue my aim or what is better, and then be more disciplined in the future. In year 2004, I did form my own firm, the legal firm. This is my firm. So the firm is still continuing until nowadays. Then also I've been practicing for over 20 years. So we are all litigator, especially in the civil and the criminal side, but now more on the civil side already. At the same time, we are doing also the conveyancing, the transaction, the property transaction also. So as you all aware that for the past 10 years, the property is boom out at that moment. So a lot of transaction going through. Then throughout all the experience, then we did discover that a lot of the weaknesses, a lot of the loophole, a lot of the cases, a lot of the disputes, they arising from that moment. So I did handling a lot of the 100 over cases. Then I make it a story. I make it into the picture, in the storyline, to make you all easier to learn, easier to understand. And as not a lawyer, but as a layman, but at least you can understand well what is the rationale behind the dispute, Why this thing happened? Because invisible hand, it means that nothing wrong with the purchaser, nothing wrong with the vendor, but sometimes the transaction cannot be gone through. Why? There's a reason why. Always a third party, always a third energy, always an invisible hand will come in to interrupt the whole transaction. This is the substance. This is the substance of the whole rationale for this course. In 2007, from 2000 until 2010, I actually worked as a advisory council member to the mayor of the DBKL. I've been there for 3 years. Very good exposure to all the level in the town council, and then we are passing all the budget. Then legally also advise the mayor regarding to the DBKL whatsoever the development of the town. Especially we have to stop a lot of the rubbish matter, and we stop a lot of the beggar also. So nowadays you look at the KL, the scenery is so good due to that the moment, the development stage by stage. We did advise the mayor also to pass all the budget whatsoever things. So look, it's me, this is me. This is me. Year 2011, I got a PhD in law from the University of the Golden State. I did some thesis for them, advised them for 4 years legally. Then finally they award me with this PhD in law. So my doctorate is come from the philosophy in law. Then from the year 2009 until now, I stand on the stage all the while. I've been talking a lot of the seminar. I've been talking a lot of the aspect regarding to the legal and the property and the commercial. This is me in many years ago. This is the moment that I have with another lecturer giving the seminar talk on stage regarding to the property, in many years ago. So from that onwards until now, from year 2009 until now, I've been non-stop, I've been continually, I'm always stand on the stage to provide the courses, to give to lecture or whatsoever the things regarding to the legal aspect and the property also, especially for this iProperty also for 10 over years by invitation. This is the picture, this is the classes, this is the courses that I've been conducted before regarding to our talk. Okay, this is a background on me. So you know me now. You know that I'm the Dr. James Ma. So I'm the practicing lawyer with well versed in the commercial law and the property law also. So may I know your name? Who is Miss Ng? Where are you from?
KL,
So what are you doing?
invest, get the rental.
So you'll be here today. You want to know something regarding to the rental,
Yeah,
right? Something regarding to the property, rental property.
yeah.
So what you expected from this course?
I cannot find the tenant, so how?
Tenant run away. The tenant run away.
Yeah.
You cannot find it. Then you cannot collect your rental. Then how?
I can break in. I can cut
Okay.
the electric or water bill.
Can you break in? Can we break in without paying rental? This is the issue. This is another invisible hand in the real world. So must be very careful. Must be very careful. All the while, when the people rent your property, they didn't pay you the rent. Doesn't mean that you can break in, You want to break in, you have to apply for the court order, for so-called the distress order to break in. So you cannot just walk in like that. In case they may launch a police report regarding your break-in to say that they lost something, there's a loss and damages, then you have to compensate them in future. That's very headache.
The electric, their half year also never pay for few thousand already.
This is a very common thing. Electricity, water, they didn't pay. At the same time, by under your account, the landlord account, but you have been chasing by the Sabas or Interwater for the payment. So that kind of area in rental or what the things, or they didn't pay for the utility, then this really cause problem is nowadays. This is a common issue in nowadays. A lot of people did encounter it. So these are quite common things. But you should know how to settle it, or otherwise, if you settle wrongly, you'll be involved in the court case already. They may take the action to sue you. Why you break in my unit? Why you cut off my water? I just owe you the rental, but doesn't mean that you can cut off my water. This is another issue. Okay, so Miss Ng is come from the property rental background. So how about Mr. Locke? Property agent. How long have you been going the property agent?
Around 2 years.
Around 2 years. So okay with this property agent?
Still learning many.
Still learning. So new agent. New agent is good for this course because this course actually is trying to expose something, expose yourself to all the weaknesses and all the problems that the property transaction, whatsoever the agent or either the banker or the lawyer, they should know very well. Otherwise, you have been stuck yourself into the court case in future. This is a problem. So it's a good time for you to come over as a property agent, come over here to learn all about this. In future, you try to invite more friends to come over. Better, don't come by alone. Miss Yong, what are you doing?
I'm property agent also.
Property agent. So how long have you been in practice? Your
6 years.
6 years,
Yeah.
So doing well?
Okay, but some issue is unexpected, then I have to learn about this also.
So you did encounter any problems or not for the past?
Yeah.
So you're doing the property under the developer or the sub-sales?
Both also have, but more on developer.
More the developer case. So do you do any rental cases or not?
Very less.
Very less. More on the selling the new property to the potential buyer. Okay. Under the new cases, new development one, actually nowadays developer come with a lot of gift. Free legal fees, free loan fees, free stamp duty, free MOT. We come with the aircon. A lot of the things have been given as a gift or gift. So encouraging also people to buy the new rather than the old property.
But sometimes halfway,
abandoned. Abandoned also one of the issue. Abandoned, it means one of the key whereby when you choose the property, when you want to buy some property, background of the developer is one of the issue that you need to consider very well. Because once you involve in the abandon, then you're going to be costing a lot of money, whereby you have to serve the loan to the bank, but without the property. At the same time, you're going to be very risk also. If you didn't serve the loan, you didn't pay the loan.
Last time the Empire City is so hot, still abandoned for 10 years.
Empire City is one of the sad story. Whereby he did very well in the Empire, but Empire what? Subang Empire. But for the rest of the project, he did. I don't know why, but financially they gone something wrong, then causing the abandon. So
before MCO or after MCO?
It's before
MCO. 10 years.
Before MCO. I think they started the project in 14, year 2013 or 14. They got the DIBS also. They got the DIBS. Supposedly the developer had to bear the interest. At that moment, in 2009 until 2013, a lot of the DIBS project, whereby the developer under the development, they will bear the interest to the bank. So helping you to let you burden on serving the interest to the bank. So encouraging people to buy the property. But no matter how once you abandon, then I think the government should take seriously on this matter to resolve it. How to resolve this matter in future? At least put some strict requirement and strict regulations to let the developer to follow the rules or the law. Or otherwise,
some of my clients they face problem is their compressed loan issue.
Compressed loan also one of the issue also. Here actually this is a good point. In future, my invisible hand I will add in another point is for the compressed room. Compressed room loan actually is the issue whereby they try to sell the unit in bulk for the bank loan for taking out the money, but later on you've been struggle yourself into serving the loan to the bank. Then you'll be declared bankrupt already at that moment. So this is a very bad sad matters lah. Very sad matters. How about Mr. Yi?
I own a few property myself and help my parents to collect some rental from the.
That's why I say you're very lucky. You all own the property, you know. You own the property, very young, but own the property to collect the rental. But you must be very well. Today there's a topic also regarding to the tenancy. I think it's very sweet to you. So you should put more attention on it to see why the tenancy can become so big issue until I had to bring it on stage and display to you all and try to explain to you all why this thing happened. It's a very sad case also. Pity to the tenant. I pity to the tenant, not landlord, because the tenant have been involved into the dilemma. She did not really come into the picture who is the real landlord and another landlord. Suddenly come with the two landlords. This is a very good issue. Later on we will explain. So you come over here to learn about the tenancy issue.
How to protect property owner.
Yeah, definitely. Because nowadays, the tenancy, nowadays you see that a lot of cheating cases, you know. So as a landlord, you should know very well how to protect yourself, especially the agreement, the tenancy agreement. Without the agreement, but you rent the property to some others, then they did something illegal inside it, then when they involve the police case, the police come over to you, then you get yourself problem already. This is the issue nowadays. People nowadays cheating case a lot. They did something wrong illegally. So you should make sure that you've been protected well under their tenancy agreement. So, yeah, Mister?
Nick Mark.
So how about you?
I'm currently a legal mediator working in a law firm. And today I attend the class to get more info or more exposure to the cases regarding the property and what are the invisible hand, the actual invisible hand that is we can't see, but it's right there.
Okay, you just hit on the point. Today, I think you are the youngest among us, but this is a good time for you to come in to learn about this. Put your attention on it. You are the legal mediator from the legal firm. Then at least this is the cases. I got 100 over cases, but today, due to the time limitation, I just can bring over 2 important cases to you. But you just be more open mind or relax. Let me bring you go through whatsoever so-called the invisible hand cases. By starting my lecturing today, I need to bring you all to know that the category of the invisible hand. The category means that in terms of the tenancy, in terms of the SMP, in terms of the whatsoever the aspect whereby the invisible hand may be fall into, especially also the inherited property. The property you may get it from your parents or your grandparents, from your ascendants. So, category of the this invisible hand is important. Then later on, I will bring you all to prove it by case. The fact, the real case, this happened in the court in Malaysia. At least you see it, how people stuck into this kind of the dilemma due to some mistake or due to some point that they didn't actually handle well. Lending, they facing the consequences and they get the legal punishment. Why? Had to pay the money had to sacrifice all the energy and the time also due to this matter. So you all try to put your mind on it. You try to be focused, like empty up your mind. You just absorb it. You can put whatsoever question to me. You can interrupt me anytime, anywhere. Then when I go through my cases, you can put out your hand and ask me. Okay or not? Okay, I think this is a very good introduction sessions that we've been having just now. Then I know your shadow also. Then you know me very well. So at least from here, we will proceed our journey in this legal aspect of the invisible hand course. Okay or not?
Yeah, Dr. Mark, can I ask, I got one property, but deal with the agent. Agent say cannot be banking the one person because this property I with my husband joining. But because we didn't have a joint account, so just straight away banking. Last time should be no problem, but this time I changed the new tenants. The agent say cannot.
This is the problem whereby you always easily can be stuck into the invisible hand cases. When let's say there is a two landlord, when you pay your rental to one of them, is it okay or not? Actually, it's not. Legally, both of them are open the account for the both joint name for you to bank in that account. But if you pay to the landlord A, but without the landlord B, the name, then in future the landlord B say that I didn't receive anything. So at least you have to get the consent letter from the landlord B to agree that the lender has to pay to the A. This is another point whereby I will show you in the second cases. You can see that also.
Last time should be no problem.
Yeah.
No problem. But this time I change the new tenants, I got create a lot of problem. They are saying cannot.
We are now in the area that all the people have the awareness now. Although a lot of people they study well, they know how to complain you, they know the law also. They can ask the AI also coming in, ChatGPT whatsoever. The device, they can provide them all the info nowadays. So you cannot be simply cheating already. No more cheating case. All the things will be under the sun. So at this moment, you should know how to protect yourself. Good question also. In the second case, I'll bring up this issue also. Why tenancy sign, but suddenly come up with another landlord to say that they claim about the property, claim on the property. Why? So made the tenant panic also regarding this. Okay, so just with me, just with me, I will go through already. We start our case. Okay. Just by relaxing, starting, this is me or you, right? Then every day, the balanced lifestyle, right? Every people expected for the balanced lifestyle. So as you certainly own some money. Without money, you can do investment, right? So definitely you own some money. You do hard working or what the things, then you earn some money. When you got the money, what do you want to achieve? What do you want to achieve? Time. Definitely you want time, right? When you got the money, you want to enjoy times. You want to enjoy it, have times. You want to have a very, very healthy, sociable relationship with others. Agree or not? Just be relaxed. Agree with me? Okay. So you definitely expected the one very background, your family. You want to enjoy the good time with your family. Then all the times you're planning your trip for your leisure time. Go somewhere, how to enjoy yourself by the money you earn. This is the aspect you also expected for the healthy. Healthy, right? You want the healthy also. If the money can buy for the healthy, definitely people will buy it and spend it. So we also need the love and the compassion. So to me, the balanced lifestyle means that everyone is chasing for this, the balancing for this. Agree or not? Agree, Balancing for this. So with this kind of the small money as you earn through your hard working, can you sustain all this? Not really. Then what the people will do? Investment, good. Definitely will go for the investment. Investment means the money earn money. It's not for the hard working already. It's the money earn money, right? So people will do a lot of property investment and the stock market investment as well. Stock maybe not easy. Today is not our topic here. So stock is not our key here. So we are talking about the property investment. So regarding this property investment or the stock investment, so long as the investment, the value of the investment is involving, definitely they will involve the expertise and the knowledge. You cannot simply invest. You get lost of your money. So you need to have an expertise and the knowledge regarding the investment that you're going to invest in, isn't it? You must have an investment skill. You must know the rules of the game, how going to play, isn't it? So if you don't know market, you don't know the stock market, please don't play. Nowadays they come up with the coin also, right? Bitcoin, coin market also. So if you don't know them well, please don't play because the high risk also. The money, the more you earn, the higher the risk you're going to face. So now the important thing is that no matter whatsoever the investment, when you are involving, you should know these three very well. You should know these three very well. But today, we are more focused on the property aspect, the investment of the property aspect. You know that the property is boom up from the year 2009 until now also good lah, huh? But basically, they drastically boom up in the year 2009 until year 2012 or 13. This is a good time for the property market. So at the same time, also create a lot of problems to the investor. So this is why today the invisible hand version 2.0 regarding to the property transaction coming into the picture. Because we're going to talk about the property investment. Why this thing happened. Why the invisible hand can be exist in the property investment. So why? Because the purpose of today, we are sitting here to attend this course is actually we want to identify what is invisible hand. You should know very well what is invisible hand. Invisible hand, later on, I will tell you, is something, some energy, something at the back. Actually, they mastermind or they control whatsoever things. So you can see that a lot of the property transaction, without the vendor or without the purchaser wrong, but the transaction still cannot be go through. Why? Why? So you should know very well today, you have to identify what is the invisible hand. What is the invisible hand? Identify it, and then what is this? Then category of the invisible hand. You should know in what kind of category, which category that the invisible hand that exists. Then I will put you also to the real case study also to know very well the rationale behind it. Why I say these cases is considered under the invisible hand. To avoid the purpose is to avoid yourself being the victim in future. Something that is so normal things, just a tendency cases, but suddenly you've been stuck there already. Then the matter have been brought to the court. Why? Why? Then hopefully, because we want to gain whatsoever that we want from the investment, right? So you should know this invisible hand knowledge very well. To avoid it to be the victim, because you want to gain something, what you want from your investment, right? You want to get something back. So you should put the concentration and your focus on this. Okay, agree? Okay, the myth about the property transaction. Okay, I put a question already. Before we start our course, actually I put a question on you. The first thing, how long does a real estate transaction taken in country?
3 months.
3 months, good lah. You all got the experience. The first one is 3 plus 1 month. Transaction property in Malaysia normally will take 3 plus 1 month. So you say 3 months is correct. Agreed. Sometimes 3 plus 1. Why? When they involve in the consent, right? And when you consent may take 3 months, then go for the SMB transaction for 3 plus 1 month. Sometimes 1 to 2 years. Property transaction may take 1 to 2 years. Sometimes longer. Sometimes even longer. Cannot be even quicker, good. Because there's an inherited property also, in my case, handling for 15 years. Family quarreling, so take times. A lot of reason why the property transaction cannot be fastening and cannot be put in the time. Why? There's a lot of reasons. Second question, why property transaction and transference of the ownership taken so long time? You should know, put the question mark in your mind first. Why it takes so long time? Okay, I give you the reason. The first one, you know that, right? 3 plus 1 is a freehold. If you own the freehold property, then you may need 3 months. 3 months plus another 1 month extension of time, then you can get the deal done. Second, 3 plus 3 plus 1 month is maybe regarding to the free leasehold. Why leasehold? Why leasehold? Why leasehold?
99 years.
Huh?
99 years.
99 years, I know. Why leasehold need more times?
Consent.
Consent. Good. You're working the legal firm, that's why you know very well. We need the 3 months for apply for the consent. Then later on the transaction for the 3 months. If cannot be done in time, that's another 1 month for the extension, right? So leasehold property. Third, some of the transaction may take 1 to 2 years. Let's say flat. They may have a double consent. The local government authority consent also. Something regarding to Bumi lot, right? Bumi lot, when they want to release the Bumi title also, they actually Bumi lot title quota also, they need to apply for long time. Strata title yet to be issued out. Transaction been done for the pending for this strata title is at the moment being issued also. Then you may take longer time. Sometimes longer also because due to the teller been worn out already. It means the teller been worn out. At the same time, the property is still under the master title. Then you may need more longer times. Even longer, if the developer did something wrong or they didn't get the blanket consent out. What you apply for the 99 years, as you say, the leasehold one, actually is for the individual consent, but not the blanket consent. Blanket consent done by who? The developer. But the developer didn't do it well. Then how? Then you take longer. When you sell the property, then cannot be gone through. The transaction, the transference of the ownership cannot be done. Why? Not the wrong of the lawyers. It's due to the developer did not do well in the blanket consent when they apply. Even longer when the title or the document lost. Some people want to sell the property, but the title lost. Then how? Even longer. Inherited property. Inherited properties. It means family they fight among the dispute among their beneficiaries. So the matter cannot be solved in time. This is the issue why the property cannot be done in times. Question number 3. Can we speed up the property transaction, as you say? Can we put it more quickly? Speed up our property transaction? No. Still no in Malaysia. Why? Why? Because we cannot simultaneously, by one hand, you hand over the money. By one hand, you take over the property.
China can.
Yeah, it's a common practice in China.
Common practice in China. Yes, in China, yes, they are like that. They bought all the property by cash. So one hand over the cash, one hand transact the name, transfer the name in the land office. But in Malaysia cannot. Normally we buy the house through the bank loan. So loan, you can see that cannot be simultaneously do it. You need the lawyer to involve in for stakeholding, to undertake to pay the money also the thing to get the transaction done. So normally we need around at least as quick as possible, but also you need about 3 months to do it. So we cannot be done. You cannot speed the transaction. So procedure, this is a vendor. Now I try to explain to you the property transaction. You should know very well how the transaction gone through between the vendor and the purchaser. Let's say this guy, he's owned a property. At the same time, this is a purchaser. He got the money. So purchaser, right? Definitely want to pay the money to buy over the factory owned by this guy, right? So this person so-called the vendor, and this guy with the money one so-called the purchaser. So actually, they must have a deal. The deal may go through the lawyer or deal with the property agent. You try to bring them together to pay the VC to the factory at the same time with the money. So long as willing buyer and the willing seller, then the willing buyer with the money, willing seller want to sell, then they can make a deal. They must come with a compromise with the price and all the terms and conditions. They must agree first before going through the transaction being gone through. So definitely they put the deposit. Now it's a 3%, about 3%, but this is not the fit. Sometimes you can put 5%, 7% or 10%, up to you. Certain people put 20% also. But you have to pay the deposit buying the transaction. At least deposit, it means what? It means a temporary something, the consideration to the contract. So contract means that you have to pay something to buy the contract, to make it the contract. So definitely both of them will sign the booking form, so-called booking form, offer to purchase or offer to rent or offer to purchase. This is considered as a temporary agreement. When you sign, you have to make sure that the term and condition is there. Temporary, is binding by both the vendor and the purchaser. But as an agent, you should know very well how to fill out this form, the term and conditions. Certain people with the figures, they write something 1 million, but with the wording, they write another story. So if you're not comfortable, in future, they're going to be the case. Certain people, certain property, they may be owned by the true owner. But when you want to sell, signing this, just the one will be appeal without the other one. Then in future, we're going to be court case already. I did encounter a lot of cases. There's one of the cases, so both the husband and wife, the moment they want to sell the property, they are still very closing the relationship. So husband signed the booking form. Then when they apply for the consent, was they think after 2 months, they are quarrel. Then now they want to get divorced. Then at that moment, since the husband represents the wife to sign also, one party signed also, but the wife decided. At that moment, the wife say, I never signed before to sell. Then agent will going to be the problem, start into the matter already. There's a two owner, why you ask the one owner to sign only? Ask the husband to sign without the wife. But when they are close, it's okay. But now they're going to split already. Then the wife now suing you. Why I don't want to sell the property. Now the purchaser pay the deposit. Definitely will sue you, right? They want the property now. I want the property. But you as an agent, as a professional agent, how can you think let the two owners to sign? But at that moment, they are the husband and wife. They are very close. That's the husband side will do. But now they want to separate already. Then how? Then court case already. Another investment coming in. So definitely, vendor and the purchaser, they will engage a lawyer coming in. Then lawyer will prepare the term and condition to embed whatsoever the term and condition in the booking form into the S&P. In more detailed way. There's regarding to the price, they will 10%, balancing, bank loan, redemption statement, whatsoever the term and condition regarding the termination of clause will going to be shown in the SPA, sales and purchase agreement. So now, what did these two lawyers do? Definitely, each of the lawyer at the back, there's a bank. As a vendor lawyer, seller lawyer, they may still on the loan to the bank, right? Sometimes they may not be fully settled the bank loan. Regarding to the purchaser side, definitely his client will get the loan also to purchase over the property. So actually behind these two lawyers, seller lawyer and the purchaser lawyer, there is a bank at the back. Then bank may get another lawyer also. So what they're going to do regarding these two banks is a redemption original document. They should redeem the original document. It means that the original document hold by who? The seller. The seller bank still hold the original document. Definitely right? Because the property, he lent the money to the vendor, right? The seller before. So the original document must be, most of the time, is held by the vendor banker or vendor bank. So now, this buyer bank has to settle the seller bank to redeem the original document. What he pay is a differential sum, right? Differential sum is a part of the purchaser price Then the bank will pay the balance of purchase price. Then among this transaction, they involve in the stamp duty also. You have to pay the government stamp duty. Then the lawyer will present the title to transfer the ownership in the land office. At the same time, finally release the loan. This transaction, this is the lawyer who know very well how to get the thing done. Okay or not? Finally, you get your house. So-called the welcome possession. It means you get your key You buy the house, right? Then you get the key now. Okay, you got it done. So now, this guy, he signed the SMP. He signed the SMP with the owner. So, invisible hand come in already. You see, seller signed the SMP with the purchaser. Time may be 3 plus 1, 3 plus 3, 1 year to 2 years or longer. Doesn't matter. But now, problems come out. Invisible means transaction, even though follow out the term here, even the time here also, but the SMP signed correctly by both parties, but the problem still exists. This is so-called the invisible hand. Why? Why is invisible hand? Invisible hand means in between the transaction, there is some hand. There is a hand at the back to play the game, to interrupt the holdings. So this invisible hand in the property transaction is invisible, but yet omnipresent. Only those who understand its working can navigate challenges undefeated and avoid becoming the next victim of the real estate black hole. So I did call this invisible as a black hole. You have to understand it. Then later on, you manage to be undefeated. Undefeated. And don't be the victim of the transaction. Okay or not?
Okay.
So now I give you the example of the invisible hand. Okay, see the first scenario. The seller is declared bankrupt during the transaction. You want to buy the house. The seller in between of the transaction declared bankrupt. Then how? Then how? It's going to be very, very problematic already. Second, how did the double dealing occur in the property dealing? One day, you bought the property. Then after, when you sign also the SMP already, after 1 month, you discover that the same owner, the same seller, sell to the same property to the another person. It means the seller on the same day, morning session, sell to this guy. Afternoon session, go to another legal firm, sell to another guy. When you discover this, maybe after 1 month or what, then you discover that there's a true SMP. Sign at that moment. So-called a double dealing. It means this thing happened. Third issue is the third party caveat ended during transaction. Willing seller, willing buyer. But suddenly, transaction halfway go through, there is another third party coming to put the caveat on it to stop your transaction of the SMP. Why? Third party caveat enter the transaction to stop the whole transaction of the SMP. Why third party can come in to put the caveat on it? On what ground, isn't it? Private dealing does incur with the lawyer presence. As I told you, vendor got their lawyer and the purchaser side got their own lawyer. But sometimes, seller and purchaser, they meet to each other. They try to settle the money themselves. As lawyer know that you just pay the 10% only. Lawyer to give a lot of undertaking and the protection to protect their own clients. But their clients, among each other, they have a private dealing. When something is wrong, lawyer says stop, you just pay 10%. The client says no. Actually, I settled 90% already. Both the clients, both the seller and the purchaser settling their own money without informing their own lawyer. Because why the money? Normally you pay the 10%. Then you have to wait until the stage whereby the 90% will be released. Among this period, you cannot simply release the 90% because you are not secure. Your interest is still yet to be secure. But among the purchaser and the seller, they go to settle it already. Then how? They want to reverse the holding ban, not so easy. People got the money, people spend it out already. Then how? Fourth, wrong property being transacted. This thing happened also in my case. But today we are not going to talk about this case. There's a one owner own the 8 units or 10 units in the same row of the property. But wrong unit being transacted. It means agent mistake. With the same row, different row, let's say Jalan A and Jalan B. But the unit number is the same. It's a Jalan A for the unit number 1. And this is a Jalan B for unit number 1. But the size is the same. Size is the same. But the Jalan is different. So wrong unit have been transact. Because lawyer normally when they do the SMP or whatnot, they didn't have the site visit, you know. Lawyer normally didn't pay the inspection or site visit to the property. Whatsoever it is, depends on the grant, your title, whatsoever the particulars inside your title there. When you show something wrong, going to be wrong, unit wrong, but the wrong unit with the correct detail, but the wrong unit lah, but the detail also correct, why isn't it? So sometimes you can't easily identify it as wrong.
Cannot be what, because the different owner what.
Same owner. Same owner.
Wow, the owner so rich.
So but Jalan A and Jalan B only. So the B and A there, agent wrongfully wrote it down, then causing the court case also. This is the wrong party to sign. Wrong party to sign. Sometimes you must be very careful, even though the lawyer and the professional agent. When you ask the people to sign, the seller to sign, seller father is the owner who may not be so they may not have so much time to sign or what. They may be too rushed or what, maybe outstation or what the things. They ask their children to sign. They may ask their children to sign. The husband is busy, ask the wife to sign. Sign on behalf. So sometimes you can get the wrong party to sign. So when you want to get people to sign it, you must make sure that the IC and the person is correct. Or otherwise, don't sign it. Then work compensation cannot be delivered. SMP completely done already. It's the time to hand over the key. Cannot be done. Why? Own a lot of maintenance fees. Maintenance own a lot. Interwater maintenance, you own a lot. A few 100,000 maybe, or what? The credit assessment or what? So transaction cannot be done. Even though I pay you all the money already, come to the apportionment, the amount is too big until the seller is not in the picture to pay whatsoever the money. Bumi law and the blanket consent issue. As I told you before, blanket consent is done by the developer, and they didn't do well the blanket consent. In future, the individual consent or not cannot be issued. They must based on the blanket consent. So agent misconduct. A lot of times the agent misconduct. I did encounter one case whereby the agents when they bought the property, they put in there the figures is correct, 1 million lower. But the wording when you write is another story. So it's not compatible among the figures and the wording. So big issue already. Actually, which price is going to be the actual amount? Regarding the tenancy, now I go to the tenancy. So far so good. You just with me, be focused. Investment regarding the tenancy. Tenancy, you all collect the tenant one, collect the rental one, you know very well. Tenancy. The first one. Tenant disappear without paying rent. Suddenly the tenant disappear already. You want to contact him, also cannot get him. But he didn't pay rent. Then in order to minimize your losses, can you break in? If you, even though you break in, there's a lot of stock inside, then how? How are you going to handle this? Can you break in? No, unless you did stay in well in the tenancy agreement, or otherwise you cannot break in. What he owed you is the rental, but you cannot simply break in. Even though you launch a police report, but you cannot break in. You didn't have an enjoyment, and a quiet enjoyment, isn't it? Second thing is, tenancy still without agreement or not? It means you tenancy expire already. Let's say tenancy expire already. But the tenant still keep on paying the rental to you. But you didn't sign the new tenancy with them. The tenancy is still valid? Still valid? Without the real tenancy sign. This is another court case already. So make sure that the tenancy is signed, or otherwise you get yourself problems. Then I can lock the property without rental. You didn't pay me, I go to lock the door, lock the unit, lock the demise premises. Cannot. Not so easy. You can do the distress order, go to court, apply the court order, but it takes 3 months to 4 months. Then sometimes the tenant also run away already. Can electricity and water supplies being cut off? No. In terms of the humanity issue and the factors, normally the Shabas and the internal water, they won't do that. So they won't cut it off normally. Wrongfully locked with the distress order. Even though you go to the court, you apply for the court order already, coming out to lock the door, but you found that it's still been wrongfully locked with the wrong unit. This case is a very good case, whereby I did encounter before, but I can show you what happening. But it's a very good ground also. You see, let's say this is a unit. Let's say 4 units here. Then this is a unit A, unit B, unit C, and unit D. Unit A owned by the landlord 1. These 2 units owned by the landlord 2. Right? This unit owned by the landlord 3. Understand or not? So now there is a tenant coming in. He signed the tenancy with the 1 and 2 and 3. Sign the tenancy. They want to do is the mini market. They want to do the mini market. When they want to do the mini market, definitely they will lock it up all the entrance. They only make it 1 entrance, right? Agree? Normally, you go to the mini market, there is only 1 entrance here. They lock it up all. Conceal all. Only this. But now, he paid the rental to number 1, yes. He paid to number 2 also, yes, he paid the rental. But he didn't pay number 3. Number 3 made a lot of kacau, what the things are making headache, he don't want to pay. Number 3 go to the court to apply for the distress order to seal the unit. But when the officer come over the things, they sue for the company ABC Sdn Bhd. Because the signboard is here, right? Signboard ABC Sdn Bhd. So they will conceal here, they will seal here. Distress order will seal the unit here. When you seal the unit here, but the A, he didn't own the money to A, he didn't own the money to B, he owned the money to D. Right? So this thing happened. When you lock it, then whole mini market has been locked it down already. Then the compensation, no? It means the tenant asks for the compensation for the landlord. I own the unit here. You have to lock the here. You cannot lock this 3 unit. Then this is the thing. Wrongfully locked with a distress order. This is a real case I did handle before. Why key return is so important? When you don't want to rent anymore, the tenant should return the key. Return the key means the stop of the period of the tenancy. Termination or what the things based on the period that you return the key. You didn't return the key, the tenancy is still going on. Be careful, Then how to enforce for small amount rental? Like a flat or what, you rent for 400. Then now he own you for 3 months, for 6 months. 6 months, 400 per month. 6 months is 2,400. You engage a lawyer, maybe 10,000. Then how? So how to enforce for the small amounts rental, right? You want to chase it off, cannot. You want to engage a lawyer, costly. Then how? Then tenancy without termination clause. A lot of the tenancy agreement, due to the landlord want to save the money, they don't want to engage the lawyer to do the tenancy. They ask the agent to do also. But certain agent, they copy here and they copy here and there. Certain clauses have been omitted already. They not even aware it. So sometimes the termination clause not there. The whole agreement without the termination clause, then going to be a big issue already. Agent must be very careful of this. Okay. Regarding to the inheritance property, original will lost and destroyed. I got a will, but I lost my will. How? Is it police report can be original will? It means that you got a photo stat, maybe the photocopy or the will, maybe. Then how? Is a will contract? Is will contract? Will need to do some stamping or not? Stamping. Is will contract? Is will contract? No, will is not contract. Will, when you sign the will is still under the
Personal.
Unilateral. It means he haven't take effect yet. He only take effect upon death. So they are not signed by the both party. Only unilaterally signed by the testator. So this is not contract. Contract means party A and the party B with consideration sign each other. Oh. Need stamping? Will need stamping? No, will not need stamping. By S&P or what? Yes, but not the will. Can benefit through the testator. Your father don't want to give the property to you. You want to sue the father? Can. Beneficially sue the testator. You guess yourself. This order, invisible hand cases. So in future, you should be more firm dealing with me when handling the cases or what the things or the causes like this. You should attend. Why? Because I'm going to show you all the cases like this. This is the issue. What if the testator is declared bankrupt? Your father passed whatever the thing to you under will, but before he passed away, he declared bankrupt. Then later on he passed away. Then the will still valid or not? Testator is declared bankrupt before he passed away. But once he declared bankrupt, at the moment he passed away, then how? The property still under how? The will. How are you going to deal with the will? Can multiple will exist? I got the 3 wills. One will like that, one will like that, one will like that. Can. Which one is more valid? Latest one. Good. You got the point. Which one is the valid? Latest one. Later I will show you this part. Beneficiary still can't be inherited with will. And the beneficiary. But why the property still come to me? Under the will and the beneficiary. Supposing the property all come to me, but why I still can't get my inherited property? How to handle a caveat on the inherited property? Inherited properties can be caveat. You have to remove it before you get the transaction done. Consequences and the error in the will. You have been wrongfully tied the wrong property inside the will. Then how? This one. Isn't it? This all is a invisible hand. So the final one is the executor ignore the duty under the will. Property supposed to be, the will under supposed to be under the executor, right? But he ignored to carry out the duty. You can go to the court to ask him to comply with the terms. So testator, these are testacy and intestacy. Testacy means with the will, intestacy means without will. So question is the difference between having the will and not. Definitely the big difference. With will, you can dispose of the property to the person you want to. But without will, you have to separate under the law. Second, when does it take effect? When does will take effect? Upon death. Upon death. Any language should be used. Can will put under any language? Yes, yes, all the languages. What's the language? In terms of the property, so long as you have followed the formality, it's okay. Will executed outside the Malaysia valid? You are the Malaysian, but you executed the will in Japan, in Australia, it's okay or not? Can. You can be executed, you're outside of Malaysia, okay. Attested by the 2 witnesses, the will must be attested by 2 witnesses. Yes, must be attested by 2 witnesses. 1 witness cannot. What can be covered under a will? A lot of the things. Everything. I think that your belongings, you can cover under the will. Clause cover insurance policy and EPF. Can will cover insurance policy and the EPF? No, because insurance policy and the EPF, they got their own nomination form or nomination method. So these two normally need to be fall under the will unless you have some special arrangement. Then you have to put it under it. How about the joint bank account? Let's say you have the joint bank account, but now you want to do the will for your own part. Then how about the other part? Portion. How about the native property? The property not fall under the common situation, but fall under the native. Bumiputra or what the things. So there is you should do this or river, or otherwise it can be easily fall under the invisible hand issue. Okay, so testacy means what? Testacy means property will be disputed in accordance with the will. Intestacy means how to dispute the property. Intestacy. Testacy means you got the will, we have to follow the will, the term and condition of the will. You want to dispute your property to whom or what the things, they will follow the will. We always respect the deceased. But intestacy means how to dispute, they will fall under the law. So Malaysia is a is a country whereby our law regarding to this inherited property is quite firm, and all the law have been applied quite coverage of the law is in terms of the wide range is quite confident on this. Everything have been clearly stated. If will, we call the grant. You have to get the grant of the probate. Without the will, we call this is a LA. So when you pass away, you have to go to the court to apply for the probate. The executor will apply to the probate. Then now try to dispute according to the will. But without the will, the person, your son, maybe your wife, your spouse, had to go to the court to apply for the letter of administration to be appointed as a person to administer the property. At the same time, you should dispute the property under the law, according to the law. According to the law, later on we have a lot of session we can mention about this, but the simple way, you follow this chart. Simple way. Normally, if there's a will, we follow the will to follow. No will, we so-called the letter administration. LA. If fall under the LA, normally they will fall under this time. 3 party you need to consider if no will. The first one is the issue. Who is the issue? Your children. Your children. So-called issue. Your parents and your spouse. Husband and wife. These 3 parties were entitled. Now, let's say, pass away already. The husband passed away. The first issue is, the husband got the parents or not? Yes, he got parents. He got children or not? Yes, he got children. He got spouse or not, wife or not? Yes, the wife is still with him. So the wife will get 25% of the property. Parents will get 25. Children will get 50. Let's say, now, the husband passed away, just leaving behind the wife and the parents without children. Then the spouse will get 50, parents will get 50. Let's say now when the husband passed away without parents, then the children will get 2/3, and then the wife will get 1/3. Understand? If the husband passed away without the spouse, without the wife, then the parents will get 1/3, and the children always get 2/3. So it means if there's a 3 party involved, children always get 50. Then 25 to the spouse, 25 to the parents. If without parents or without spouse, children always get 2/3, 66.666%. 33, 1/3, 33, satu per tiga, 1/3 will go to the either parents or spouse.
Eric must have the kids. If the parents are like father passed away already, only mother here, how? Consider parents also.
Pardon?
If father is already passed away, only mother still can get 25%.
Yes, if the father passed away, leave behind the will, without will. So distribution elder will be, spouse is there, right? The mother still there, my spouse will get 25. But the father, he still got the grandfather or not? He still got the grandfather, then grandfather will get.
If no grandfather?
No grandfather, then spouse, the wife will get 1/3. Children will get 2/3.
How about the mother?
Mother will get 1/3.
Grandmother.
Or grandmother.
Grandmother.
The question is
No grandfather, only grandmother.
Also can get 1/3. Not say 1/3, 25%, 1/4.
consider parents also.
I consider parent also. Parent means either husband or wife.
If divorce already,
Cannot.
no.
Later on, there's a case I show you. There's a divorce. No more already. Okay, so sometimes the people inside the will, you need to appoint the executor, right? Sometimes they are not appointed. They may appoint the class, like a road will, like a whatsoever, the Amanah Raya or what, to be the executor for them. You can be the beneficiary. Sometimes they appoint the beneficiary to be the executor. But sometimes they appoint a third party coming in to be the executor also can. If it involve a lot of property, big amounts. So this is the thing, the percentage that I've been explaining to you just now. So are you ready to die?
Sorry, can I ask? If the husband pass away, but husband outside got extra, how to say
Another family
another family,
cannot,
the son can get the
because the legitimate and illegitimate. If you are been the child under the legitimate children, it means that your parents have been registered for marriage, then you're entitled to. Illegitimate children is not entitled under the will. Not say the will. It's not under the distribution order without the will.
But cert for my husband.
I know cannot unless they do some will to give it to the children. Okay. Unless there's a will. Without the will, if we are not direct, I mean your parents is not registered under the marriage, then it means you have been distributed under the Distribution Act, and means you are not entitled to. Illegitimate child cannot.
Example, they didn't marry, they have a children.
Yeah, they didn't marry, but they have the children, right? Illegitimate child, illegitimate child. It means children without marriage.
But the guys are no married, totally no married, only have children.
Yeah, it means the children without marriage. Children with the children, but without marriage. Father and mother not married, but with the children. So this is called illegitimate child. Illegitimate child.
So no wife, no parents, so how about all the
unless husband and wife wife pass away, then if the husband pass away without parents, then children get 100%. The children get 100%.
The question is if they're not married and get kids, and the owner pass away, then the property how to distribute, how to arrange?
Then he got a sister and brother or not?
All pass to sister and brother.
sister and brother
Then the kids, one set also, what?
Husband and wife not married.
Yeah.
Husband didn't have the parents. Husband passed away, let's say husband passed away. Husband didn't have the parents. At the same time, husband got the child, but illegitimate child.
Yes.
But no will.
Yes.
So distribution under the Distribution Act 1958, under the brother and sister.
Unless you got will.
Unless you got the will to say that I give to this guy, okay. Will, you can dispute your property to any third party as you like.
Maid also can.
Can.
In Singapore, kids.
So, are you ready to die or not? Without will, without will, don't die. No, you have to make sure that when you pass away, everything must come into the very peaceful. Okay. So far so good. So I've you all gone through all the matters already. Now I try to bring you to the practical cases. Legally, I try to bring to show you all the this category of the invisible hand, then the possibility of the matter, and then the transaction of the property from the vendor and the purchaser. Then among them, through the transaction, they still encounter a lot of problems, right? But now I bring you to the practical cases.
I got one question. Just follow the rules just now. The wife get 25%. Kids the most priority. If I do a will and say wife get 50%, then kids 25%.
Under will, okay. Under will, I don't want to give to my wife. I give to my children. Okay. Will, this is the important of will. We want to give to whatsoever the person you want. I don't want to give to my child. I don't want to give to my wife. Can. But now the situation fall under this without the will. If no will, then you have to follow the 25%, 1/3, 50. It's without the will. It's under will cannot. Okay, Okay. Now, I will go to bring you regarding to the practical cases regarding of the inheritance property. Inheritance property. Why the beneficiary cannot get the property under the will? Even though the father, before pass away, do the will already to give it to the children. But you still cannot get it. Why? Invisible hand come out already. Second, what happens if there are two will exist? Two will. When you show some will, another guy show another will. Then how? How can the property under will be created? The father pass the property to you, but suddenly in the process of the transaction of the property, some people create the property. How? My case, my firm, legal firm now, is going to be handling another case regarding this matter also. KV is coming in. Next Tuesday, there's an appointment also have been fixed to see this also. Why that fellow want to KV the property on the inheritance matter? Number 4, can beneficiary sell the property under the will? Father pass the property to you, you want to sell it? Can. Number 5, is there any difference between the promise gift and the will? I promise you, you're hardworking, in future, I'll give you so much of the money. Promise. This is another court case also, but today I got no time to show this. By promise or by will? The brother promised his brother a lot. You work for me, in future, I'll give you a lot of things. Then the younger brother doing this for them, maybe 20 or 30 years. Today, the whole company became a very big company already. But before his brother passed away, he do the will, passing whatsoever the property to his wife and the children, without leaving something for his brother, who had been promised before to fight 20 or 30 years to build up the whole business for him. Then how? This is the case. Okay. Now we go into the very interesting part, whereby this is regarding the story. Now you just listen to the story. Listen to the story. An Indian boss story. Unrelated beneficiary. Unrelated beneficiary. Indian boss story. This is regarding to the inheritance problems. It's a very sad case, but handling by me in I think it's a 2008 or 2009. I will go through it very, very slow. Let you all get a real picture. Because you did have the legal background, then your understanding may take time. But in order for you to get the whole rationale of the back of the story, then you should go slowly. I go slowly, then you can understand it why. This is an Indian boss. This is an Indian boss. Here's a company. By this company, he's doing a lot of transportation, logistic business. He's doing the logistic business. All the while you are thinking about this, lorry lah, the ship lah, and the aeroplane or what the things are logistic. But he from the small company, then later on bigger and bigger, he's doing more on the lorry one, lorry one. Transportation business. He's doing the lorry business. As I noted, he's doing the lorry. So through the year by years, the lorry getting more and more and more. Then business become bigger and bigger. Earn the money, isn't it? By doing well the business, definitely the money will come in by itself. Then over the years, money, definitely you got the money you want to do. Investment, buy property lah, buy this, buy that, develop your company, then definitely buy the property. Most of the time when we got the money, especially for the 10 or 15 years ago, the property is boom out. All the people definitely will buy the property. So in year 2004, 2005, 2006, he bought a lot of property also. After buying all the property, definitely he gain more. Property boom out, isn't it? The good price for the property. You buy, sell, also you earn a lot of money. So getting more and more money. But this Indian guy is a very ambitious guy. It means that he always come with a dream. Or he's not been like a normal people. Extraordinary people with ambitious, he wants to make bigger of the business. So now company become bigger already. You see the picture also become bigger. So company turn into the very big size already. So definitely he bought a lot of lorry also transport also, and then getting more and more the property. Getting more and more the property. Okay or not? Huh? So chasing the dreams. This has been accounted by all the commons like us, ordinary people like us. You got the money, you're chasing a dream. The more the money you have, the bigger the dream you're going to make. Right? Okay. Back to the reality. Now we try to see the background of him. This guy with the money, now with the company, do a lot of transportation logistics business. He did marry also. This is his wife. His wife. This wife, why put the flag there? Playing the politics law. Politics in Malaysia is the MIC one law. All the while, gila with the politics. Politician. Then politicians, they are very, very busy. All the while giving speech here and there, attending a lot of the dinner and a lot of the function or what the things. So most of the time, he didn't with him together, or did not come back home also. Busy with their politician mind. So now, politics, this picture shows that he become famous. Then all the while supporting here and there. Then Holland, why Holland? Holland, it means the Chinese word in Holland means Holland. It means she did very well in the political life, but he sacrificed her own family life. So the time with the husband, the time with the children, sacrifice a lot. So it means Holland means you put something worse. Due to your political mind. Then you make something worse in your family. They did marry before children. Then political activities getting more and more. Giving speech here and there. Then all the while meeting with people, solving the social problems, solving a lot of these society matters. This is all the political been done before. All the political done. So they have no more trust among them. It means the husband and the wife now, they got the tsunami in their trust. Tsunami in their marriage life already. So marriage breakdown. They are divorced. They end out the marriage with divorce. So the heartbroken. Get it? Heartbroken, confidence level down. No more confidence already, isn't it? The husband very sad. You go into the life, even though you got the wife, but if you didn't have. Holland bigger. Family problems even bigger and worse. Okay, this logistics guy doing business very well, but with a very poor family relationship. Due to the wife, gila with the political activities, gila with the political ambitions. Then always not away with him. Then the heartbroken, the marriage down. Okay, get it? Holland bigger, Holland not to the wife, to the husband. Husband cannot handle well the family. The husband, but beside the family, beside the marriage life, his trust level very, very high in terms of the business. So he put more of the time, focus on his business. He did establish a team, mostly Chinese support him. Then this team is a very bigger teams. Then this team very support him. Then even grow the big business. Even grow the business become bigger. So over the years, earn a lot of money. But he also willing to share all the money amongst the workers. So his team actually with the money compensated them. Then be more confident be more confident. Then among them also, they've been chosen to become a small team to do the management in terms of the decision making of what the things on behalf of the boss. I know that at the latest year of his life, actually the management is completely take over already, the whole things, even though they signed the check for him also. The moment when I involved in their legal case. This management teams, when they come to me, after he passed away, they did sign the check also, authorized by him to sign the check on behalf of the company also. So it means
bank no freeze, right? Because the people is
not say pass away. It's before that. It means that the year before that he passed away, he did authorize these kind of people to sign the check for them. It means authorize the signatory mandate to this team to do whatsoever to run the business for them. So it means that the trustee between them is very strong. Very strong. They actually can represent him to do whatsoever the decision of the commercial decision in the company. Until one day, invisible hand always occur when there's a certain so-called until one day. Until one day. Before until one day, everything was going to be okay one. But until one day, something's happened, no? Isn't it? Until one day. He's getting old already. At this moment, I still haven't come to the picture. After he passed away, people come and see me to talk about the inheritance property. At that moment, I come to the picture. But when he's getting old, this story I get it from his workers. When he's getting old, then how? He got the children, right? He married before, right? Now getting bigger, right? Yeah, when he's getting old, he's getting bigger, right? Isn't it? The children getting bigger. So now, the wife still killer with the politics. Still killer with the politics at that moment. Even though have been divorced already, but still getting involved herself actively in the political life. So with this kind of money in hand, he got so rich. Where the money should go? Where the money should go? Is there any problem with this kind of money? Those have been divorced, married before, with the team of the company. Where do you think the money will go to? Do you think any problems will be created after this or not? Then let me tell you the story. Sooner or later, pass away. When he passed away, then now issue is who were going to be inherited, whatsoever the company and money and whatsoever the property have been bought before. How?
normally give children one.
Normally they will give to the children. But now, the first issue is what? Yeah, good. Definitely the first question is there any will or not? What kind of term you put in the will to assign your property out to the beneficiary? Who is the beneficiary? The first issue you have to see, is there any will or not? Yes or no? You don't know, yes or no? There's a will. Good question, So, if there is a will, let's say if there is a will, you have to dispute the estate strictly following the deceased wishes, as outlined in the will. Will say, I give to A, you should pass it to A. B to B, B. As a deceased will, deceased wishes. If there's a will, you must follow the term as outlined in the will. If no will, then how?
All the children, no?
If no will, then you have to dispute under the Distribution Act 1958. Follow just now the parents, the spouse, and the children. Remember or not? The spouse, parents, and children. 50 1/3 2/3 isn't it? According to just now, as I say. If no will. If you, follow will. No will, follow this.
Means example, he already divorced, no parents, means 100% give all the children.
Yes. If no will. Is there a will? Different story. But do you think he's got the will or not? Do you think he got the will or not? Do you think he's so stupid, man? So rich of the money, they work with the thing, with a good team, the management team in the company. This guy passed away with a wife, children. This is his previous wife, ex-wife. This is the children. So if no will, if he dispute under no will, it means what? It means this is their parents. This is his parents. His spouse, and children. So no more parents. He's getting old already, my parents also passed away already. So no parents. Second things. Supposedly wife get 1/3, children get 2/3. Isn't it? As under the Division Act, 1958. So now, wife, divorce. So no more. Right? So no more, divorce already no more. Not entitled to. So you have to go to this side. Isn't it? So children will get 100%. Isn't it? If no will, the whole thing, the children, among them, disputed among the 100% of the property owned by this Indian boss. Okay, understood? Clear? Clear. But now, these children also didn't get it now. They're not entitled to. Why?
Got view.
Got view. Good. Got view. Why? Why didn't he get it? Because he had a view. He got a view. Who will be the beneficiary? You can guess already, So much of the property. Who will entitled to get all this? To get all this? The view. Wife? Divorce. Children? Didn't get it. Who? So once you divorce, you're no more entitled to. You're not considered as a spouse anymore already. Ex-spouse cannot get. Children, they didn't have. They didn't have. So who will get this? Workers. He did the will. He put all his workers as a beneficiary of all his property.
Wow, I also want to get like this.
Indian, give it to the Chinese, mostly Chinese workers. You didn't expect that, no?
How many workers?
20 over 30. But the management, just a few. The management, the management team, just a few, 5 or 6. So now, because this team, all the while, as I know that, when I'm dealing with them, they are signing check for 10 over years. When he getting sick already, before he passed away, the management team do all the business decision for them, collecting rental, everything for them, So even though signing the check for him also. So it means that he entrusts them. He put all the confidence and trust on them. Then they told me this Indian boss is a very nice guy. They work like hell fight for him, But now, with the view, they come to me, this is the moment I come in. See? They come with the view, bring the view, come to me, talk to me under the view. So under the view is what? You have to dispute the property according to the term embedded in the view. Right? So I'm quite confident, They say, okay, no problems. Okay, view clearly state that you're entitled to all the things. They got the property, money, and all the investment. The company also. So I got the confidence. I have a confidence level, quite high the confidence level. Then I say, I did advise them. The first thing is you are the administrator, never mind. You go to the court to apply for the probate first. I can go to the court to apply for the probate. Probate is what? Probate is the execution right granted by the court for you to administer the will. So we call the probate. If no will, then you go to a court to apply for the order to administer the property. We call LA. Without the will, we call LA. With will, we call probate. Just the name different only, but the purpose serving the same. So with the will, you must go engage a lawyer, go to the high court to apply for the probate first. You have to among them choose one of the person. under the will have been written there already. Who are going to be managed my will or what the things? If you got the children inside your beneficiary, let's say there is a beneficiary below 18 years old, then at least 2 executor needed on that. You need to appoint, when lawyer do the will, you found that the children is very small, you better ask them to engage two executor. If the property is passing to the majority age of the children, then it means all the children above the 18 years old, then no need, one will do. But can the beneficiary become the executor? They are the beneficiary, right? The body pass to them, right? Can they become the executor? Can. Beneficiary can become the executor. It means I'm the beneficiary. Property passes to me. But you appoint me as an executor also. Can, no problems. So they engage me, go into the picture, go to the court, apply for the probate. Definitely 1 or 2 will be appointed as a probate, as executor. At the same time, after probate has been granted, then the second step will go to the distribution order. How to distribute the property according to the portion and the percentage inside the will. This is called the stage order, distribution order. Isn't it? There's a 2 stage. Apply for probate to let the people to be appointed as a executor first. Then he can sign on behalf of the deceased. Then second step will go to be the distributor according to distributor property. Now, clear? With you, we call executor. They have to apply for the probate. Then beneficiary, B1, B2 is a beneficiary. No will, we call administrator, LA. B1 is a beneficiary. So stage 1, apply for the probate. Second stage, apply for the distribution order. Let's distribute the property. According to your term, let's say you must be rich until which age or what the things, then according to the term of the will. Okay? So who is the executor? Is a person. Who is the beneficiary? Same team, the team. All the workers in the company. So since they're looking for me to get all this, then with the will together, I quickly applied it to the High Court in KL. Because applying for the probate with the will together is a very easy job. Not unless you got the dispute, or otherwise it's a procedural matters only. So with the will, I go to the court, apply to the High Court to get the grant or the probate grant. To dispute the property, money, and the investment, the company also, to the beneficiary. Understand so far? But now, how? Problem. Since I say that this is going to be the very easy job, right? But why I still encounter the problems?
Why?
The son. You see? Everything is go so smoothly. Invisible hand come out already. Invisible hand come out. The normal procedures with the will clearly stated, black and white stating that you are entitled to whatsoever the things, still can be challenged in court. Why? Suddenly, all the transaction in terms of company, money, property, all what things have been caveated in court. It means the transaction all cannot go through already. Who caveat this? Children. The children. Their reason is that I'm the issue of the disease. Their father and the children. Why my father didn't pass the property to children? Is it that they pass it to the third party?
Single side also didn't.
Not even a single cent. Not even a single cent. They never paid a visit to their father before, even though he was sick.
You're not looking with father.
This is the issue. Reason, they caveat the property. The first one, immediate issue. I'm the son. I'm the daughter. Why I didn't get the property? Issue, right? Definitely, father passed away. Why the children didn't get the property? Why not? Second issue, I got the will. He also got the second will. They bring also one will to show that they have a will. And problem with you. I got a view, he got a view also. Then two view exist. Now, second view coming in. This is the first view that I've been getting from the workers. This second view brought by the children. Go to court to say that there's a view. So, which one preview? Was the latest? You know that view, view was the latest. First view and the second view depends on the date. Depends on the date. When you do the view, the first view you do already. Second time, later on you do the second view. Then automatically the first view will going to be void. Why? Because there's a formality inside the view. The first sentence inside the view, you must put like this. I, who and who, at this number or what? Of Jalan Mangkisan, Taman Rambutan and Durian. Colombo. Being sound mind and health, do hereby revoke all my formal views, codicil and the testamentary disposition. I revoke whatsoever the thing I taught before. Let's say you are single now, you do the view. Then after that you get married. Your marriage will automatically revoke the view you have been done in your single time. Understand or not? You should always remember, when you are single, you do a view, later you get married. Automatically, you don't need to cancel the thing. Automatically, he will be not valid. Turn into not valid. Why? Because at that moment, you got the family, you got the children, you got the wife. Then another story already. So this is.
If I'm married, I didn't do the view. So
last time you do the view, after you married, you didn't do the view, then previous view automatically revoked by marriage. Revoked by marriage.
But even after marriage, then the will I made is the same as the will as when I'm single. It's okay lah.
Yes, you got to do another new will lah. Because at that moment they were going to be considered your family your children and your wife or what, and your husband or what. So this is the first sentence of the will. Always we will put like this: revoke whatsoever the formal view, isn't it? So since they got the second view, it means that they were going to revoke my first view. Then, if the thing make it so clear cut, then definitely no more court case, isn't it? Then you don't need lawyer, So why you need lawyer? Coming in, definitely there is another argument, isn't it? First view gone. First view gone due to this. They put this to say that first view out, revoked. Preview. Get it, So this view is belong to the workers in the company, and this view is belong to the children. So how about the money? How about the company? Fight each other now. They should fight each other. Which one is preview? Which one is preview? Then police report. A lot of police report. You are like that, launch police report. That, launch police report. I know that just close the times. A lot of police report be made. So this property belongs to who? Now I have to let the court to decide, isn't it? By argument, issue.
Two will is a real one.
Two also the real one, but we have to see how To see how. You say the second view, right? Then how does it exist? Then with what condition you have to see, isn't it? So I bring back the issue to you first, because legally, legal way we always want to talk about the issue. What is the key? What is the key point for this to argue? We argue for what? Now we argue for first view and the second view. Can second view revoke the first view? Is there second view valid? You just see lawyer, isn't it? Validity. The first issue, we talk about the validity of the second view. I believe that this view is wrong. Is something invalid, something is falsified or what the things may be, isn't it? Second, the issue. Who is the beneficiary? This view, preview, it means they are the beneficiary. If this view not valid, then they are the beneficiary. A lot of money, Who going to be the executor? If this will prevail, they are going to be executor. If this prevail, they are going to be executor. Executor. So this three issue will be to decide. So both lawyer, they also got their lawyer. I'm standing here, they engage another lawyer coming in. High Court, Colombo High Court, in front of the Jalan Abdul Samad. Is a old High Court, the old building one, old High Court. Regarding to argue about these three issues, the validity, who is the beneficiary, and the executor. Argument, a lot of argument. Issue, the first issue. The first issue we argue, I made a conclusion already. The first issue we argue is the date. The date. Our date is earlier, right? The second date is later. Later. So this will have been done before, ma. So there's a 2 or 3 years already. As I know that this is a 2 weeks before he passed away. 2 weeks passed away. So the date. Our day is more than 365 days. Their day is just more than 10 days only. They are very near to the day of pass away. Issue number 2, signing. Our view, sign with the pen. Their view, sign with the dumpling. Their view, sign with the dumpling. Then we truly believe that this dumpling, how to get the dumpling? When you pass away, the body there is still get the dumpling, right? So they sign by the dumpling. But not signing, but with the dumpling. Signing. Third issue, sound mind. Third issue is sound mind. View always say that I with the sound mind just now, right? When I reward the previous way with the sound mind. It means rationally, I stay alert. What's happening? Sound mind. This view, when he dies, when he's getting old, not sick, old, he do the view. So, sound mind, no? This one, he's in the hospital already. Inside the hospital already. You are maybe in the coma or certain things we don't know. But not in the very good, healthy, not in the very good, considered as not in the good, unless you got the doctor to come in to tender the expert evidence. Isn't it? So, unless they prove it, the doctor proves that, yes, at the moment I see it, he's in the sound mind, he can sign, or he can dumpling, or what, I see it. But unfortunately, no doctor.
How about the witness?
Their view. There's a witness also, they can prove it with the witness. But when you say you're the coma inside the hospital or what the things are, at least you might have a expert evidence to come in to say that, doctor, come up with the doctor testimony to say that you are in the sound mind to make this kind of decision. But can't prove it. They can't prove. So finally, it's other witness. We call other witness also. I call their friends. I call these Indian boss friends, neighbor, workers to say that yes, good They got the quarrel with family Why why not take care of it Children not even come and see him Then all the while when he's sick in the hospital all the workers go to assist him go to visit him or the things to help him but not the family. But they also call the witness also. To say that we got the family we got the family or what the things. They also call the witness coming in. So our argument is that 3 years already, this will have been done 3 years ago, before he passed away. Signing, by pen signing. Poor family relationship. This Indian boss had a poor relationship with his children and the family. Reason not for family. He did stay inside the will. I don't give the property to my wife because like that. To my children because like that. You're not loving me. He put the reason inside the will. He put the reason. This side, they argue that the will is about 2 weeks before he passed away. Dumpling, not signing. Good family relationship my father loves me everything Then distribution for to family, 100% distribution to family. Isn't it? You see the comparison You see the difference between them. Then now how? How? So Judgment Day, Judgment come up with they're not favor to them. It means the second will is not valid, so it means the first will stand up, then they will preview, then they will belong to this group of the people. So caveat had to be removed. The court asked them to remove the caveat removed. Then all the transaction can be gone through already. Happy ending? Happy ending? No. Not so easy. We can talk about the money. No. Not happy ending, Why? Nightmare just starting. Nightmare just begin. Nightmare, These children, they're doing what? They're now, even though they said this preview, they don't care. They keep on conflicting, keep on asking, keep on creating problems, fighting each other, launch police report at things, kacau the company, give to the company, then lock the company door or what the things. Then both of them turn out into angry bird, become bigger and bigger already. Then gangsterism coming in. They ask the gangster coming in to disturb you, to interrupt you from the company operation. What they can do to interrupt you Gangsterism coming in. Then you all know that this group of the people is more kind, isn't it? So finally what? Agreement, come to the consensus, sit down, talk about it. They get lesser, they get more. I forgot already the percentage, but they get around 70% or 80%. They get 10 or 20 only. No more choice. Then I'll separate the money, sign with the agreement, how, They don't follow the will, They don't follow the court order, Gangster coming in, every day just move around your company, Kacau, So this thing happened, a very sad case, So KV issue coming to the property transaction. So to them very sad case. So finally they put for sale. They close out the company. They close out the company, they put for sale the property, then they get the money. That's all only. So regarding conclusion, now I come to a conclusion. Conclusion and the solution for this. The first thing, when you do the will, you must follow the formality. You must follow the formality. The format is that the first thing, will, you cannot say I give my will to my son. You cannot see like that. This is just a statement, but it's not a will. Will, you must have a formality. You must follow the format. The format must be the first one is the sound mind. And the sound mind. Then I revoke all my previous will. Isn't it? As I explained just now. Then I appoint this guy as an executor. Then there's a specific the property. This house in which area is a double story or what the things giving belong to, be netted to who and who and who. In what percentage and percentage. Specific the property. Which property? Where is it? Address, grant number, everything you should put specifically. General property means what? Like my cars. You didn't put your car numbers. In future you sell the car there how? Isn't it? Otherwise you should replace your view. To update your view. Take time. That's why you show all my cars, all my jewelry, all my cars, all my watches, or all my fund in the account, all my FD in which bank. Like that. It's a general property. Then sometimes undestroyed property. Inside the will you should mention, for whatsoever the property which I may be forgotten. Maybe sometimes the will will be done already, But before you pass away, suddenly you buy another property. But you forget to put under the will. Isn't it? This property will fall under the undestroyed property. But sometimes when you engage like a famous company, they are doing the will they will charge you, isn't it? Clause by clause. Isn't it? I don't want to mention the name, you know about it. They did charge clause by clause, so people want to save the money. When they want to save the money, they may put I got two property, he specified the two property. But he didn't put this undestroyable property. Then before he passed away, he started to buy another property. but he forgot to put under the will. Now, under the will, only can dispute two property only. Another property not fall under the will, you had to go to the LA to dispute it. So the cost for you to apply to the court underground and under LA, double cost for legal side. I tell you, be careful. So you better put this clause in whatsoever the property that I may not forgotten or I may not be putting manage to put it under this will. It's fall under this category and disputed to who and who according to what percentage. Then definitely you should mention about the beneficiary. I will give to who and who and who, my beloved son, my beloved wife, my beloved who and who. You should say, mention it. Definitely you can give to whatsoever the things like mistress or what the thing you can. Up to you. But don't mention my mistress. Okay. Issue not be netted. Listen. Let's say you got the 3 children. Then suppose everyone got something, right? But due to these children, this A, B, C, maybe number A, he did own a lot of money to other people before. Then the father did help them before. Then he may not entitled to. Or the father don't want to give him anymore. Then he gives to the second son and the third son. Then now the issue coming in already. Why? Why as the son of my father, I didn't get nothing. I get nothing. Why? Why? You state the reason. If you got the 3 children, you give to 2, another one you don't want to give, you state down the reason why you don't want to give to him. Why? Because if you didn't state properly, in future, he will challenge it to the court, to say that, see, I'm one of the son also, why I didn't get anything. So he will put the caveat on the property. Then the whole transaction cannot be gone through already. So when your property under this situation, if you have been caveated for the third party or whatever the things, the beneficiary, the whole transaction cannot go through. The case may be dragged for 2 years or 3 years. Then who will serve the loan to the bank? Then will go to be put under all the lelong already. I tell you, inheritance property, if you didn't handle it well, then someone among the son, maybe one of the son he didn't get anything, he may put the caveat on it. Then rendering the other 2, the whole property, no people go to serve the loan and whatever the thing, all the cash flow have been jammed. Then the problem is that they will force sales under the bank. All long already. Then problem. Signing. Use the pen to sign. Dumpling is the critical moment. Maybe use the dumpling, but have to put by the expert evidence to say that you are in the sound mind. 2 witnesses, attendance, 2 witnesses. Certain people, when they sign the will, the requirement is the 2 witnesses. But they go to the house, let the A witness to see. Then I'll go to the B house to let the B to as a witness. Cannot. This both the witness must be attend together at the same moment. Even though inside the one hall like that, he's standing there, he's standing here, or what the thing is okay. You see it, you sign, you see it, you sign. The witness, they don't know what the content. They are just witness to the signature. They are not witness to the content. Yes, I see you. You sign the thing. Okay, ready to go. They are not witness to the content. I want to give to who and who the thing like that. It's not in the will is not a contract. Will is done by the testator unilaterally. Doesn't mean that the beneficiary will go to agree or what to be the party B to will in the offer and offering like that. No, not such the things. So will is not a contract. So non-stamping.
Excuse me. Executor, if the executor is passed away already.
That's why when you come to see me to do the will, definitely I will spare by another executor. I will do the one executor first, then say that if the executor reluctance don't want to proceed to carry out their job, second executor will come in to stand by. Then if the executor pass away, then you leave it to the court to decide already. So formality, a lot of the will inside Malaysia there, they didn't put the issue not to be correct the reason. You don't want to give to who? I don't want to give to my wife. You state the reason. I don't give my son. State the reason. I don't want to give to my parent. You state the reasons. To let them cannot to let this will cannot be challenged easily in the court in future. We're going to be dragged a lot of times. Let's say just a hypothesis no will in this case. Same outcome? No good. No. Let's say this case, no will. No need fight lah. Under the issue already, issue the children will get the 100%. Isn't it? Not the same outcome. So, solution is you want to do the will, make sure your will is valid, you must follow the formality. The will formality. Don't do the will yourself. You engage a lawyer to do it. Second, state the reason why not be credited to the next of kin. Why I don't want to give to you? State it. Three party, right? Parents, spouse, and the children. I don't want to give to them because my mother spent a lot of my money, so I don't want to give her anymore already. You stay there. In future, they cannot challenge. They're not easy to challenge. Then you save a lot of time, court in time. You save a lot of time to save the property, or otherwise property will fall sales on the bank. The third thing is the filial piety. What's the filial piety? Obey to the parents lah. Parents say what? Parents sick or what? Take care lah. You want property, you take care ma. You don't want to take care of the Indian boss, then later he don't want to give you, then you fight in the court. Isn't it? That's three reasons. This is a solution. You want the property be filial piety. You know filial piety? 孝亲敬老 filial piety.
I find that this case, lawyer is no use.
No. Law is still the law. Law is still the law. We won the case in the court. But some things regarding to the out of court is a different story. Any questions? So far so good, So far so good. Interesting, right? Okay.
How long the case?
3 year plus.
3 years.
Just 3 years to.
3 year plus. End up in 2008 or 2009. Case started in 2005 or 4, 5.
So they spend quite a lot also.
This is in Selayang one, Selayang case. Okay. If okay, then we come with the tenancy. This is another interesting case regarding to the tenancy. We take a break?
Yeah.
We take a break, We take a break for 5 minutes or 10 minutes?
10.
Okay. Okay, let's come back. Okay, let's come back. So regarding the inherited property, any questions?
If example, got 3 children, either one is passed away already, but I never do the
Yeah,
deed.
if one of the beneficiary pass away, it means under the view now, then one of the beneficiary pass away, going to be very problematic again. Next week, I have another meeting with my client also regarding this case also. The first view going through halfway through only. At this moment, the beneficiary pass away. Then how? You know that?
Sorry, say one more time.
It means the moment the inherited property being transacted under the view, halfway through, suddenly the beneficiary pass away. One of the beneficiary pass away. Then how?
They got family, man. Beneficial.
Let's say the father passed the property to the 3 children, A, B, C. Let's say A passed away suddenly. Then how?
A got wife also, then got kids.
Good,
Still one family.
good. If A passed away suddenly, then the first question is depends on whether the A got the will or not.
A no will.
If A got no will, then distributed under the Division Act 1958. Then his portion, the father give the one third to the children, the 1/3 one, you go to dispute accordingly to the Distribution Act 1958. So it means that this is a LA, previous LA, go to the another LA. It means like this. It means like this. Father to the 3 children. A, B, and C. But now, halfway through the transact of the property, A passed away. Then depends on the A got the will or not. No will, got will, then how? But if A got a will, let's say A got a will, but A just mentioned about his property. He didn't expect that his parents, his father, got the property transacted, inherited to him. So this property will fall under the no will already, LA, isn't it? This property to him is fall under LA. His property belongs to his own name. There's a will, that fall under the will to dispute. So according to this LA, he passed away, then depends on he got the parents or not. Let's say he got the parents, he got the mother here, mother. Then mother will get 1/4. Spouse, he got the spouse, get the 1/4. His children got 50%.
This will certainly raise issue in later on if like transferring properties, right? If doing transfer for the properties, this will certainly bring a lot of issue, right?
So you have to wait until this transaction got to complete first. You cannot transfer anything out without the thing, isn't it? So you have to wait until this portion transacted to the A, B, and C. But for B and C, no problems. But for A side, you got to get this transaction done first before you transfer out to the another beneficiary here.
My husband grandfather that time got one property. Passed away already, but so many years never do do the LA. No view lah. Never do the LA. So the property still leave it like that until nothing.
He got how many children?
3 children.
3 children. Let's say 3 children. Pass away already with the property with 3 children. But now no view.
2 uncle already passed away.
No view.
Also no view.
No view here.
2 uncle also.
No view means LA lah. Then another 2 pass away already.
Yes. One no married, one got married.
Then this one got view or not?
Both
Let's say
no view.
no view. So under LA. No view under LA. So it means very problematic. Take a lot of time. So you need to translate to them. They pass away already to their children. So let's say this got 3 children. Let's say three got 3 children. Then you get all the children here, to attend for his portion. 1/3 here. This view go to the 1/3. Let's say the children get the 1/3. Let's say 1/3. So you must make sure that the property 1/3 is transferred to here first.
So some already go for overseas. So the house already empty. Everything.
So later on, this means selling need to get all their agreement if what they want to sell off the property.
If one of them, the brother here, if one of them not agree, then problematic already. Then now, you see, I want to, as a lawyer, we have to make sure that this property now, have to transfer to these three brothers, right? But 2 of them is passed away. But now issue is that this portion, his portion, will be represented by these 3 guys, So you have to make sure that these 3 have to attend the meeting. So for this portion, 1/3, these 3 persons must attend the meeting. But if this guy not agree, let's say he's not agree, then the whole transaction cannot be done.
So
The whole transaction cannot be done. This is the case that I entered in the Klang one. I settled this for 15 years.
like that good.
Because then make sure that this all healthy, If this one pass away again, there's another children, then you should make sure all the thing agree. But you should know that from the same family, even though the different people, but they come up with a different idea. Certain people want the money, certain people want this, one there, one there, one there. They want to stick around together, difficult.
Now left the empty land like that. We sell off already also cannot cover the legal fees.
You cannot sell off also.
But the case I handled before is this one, the price going out. The property left behind is 1981 or what, 80 like that. At that moment, the bungalow. Until now, there's a few million already. That's why quite worth. But he got 10 to 15. He got many children.
Few hundred only.
So passed away or what the things has to be preserved by his son, be preserved by his children again. They're coming in to sign all the letter on behalf of this to make sure this transfer to their first, to him first, or directly to them also can. But to make sure all agree. But previously, this guy agree, right? But he passed away already. His 3 children must agree. Not easy, Not easy. You want to make all the people sit down together is a hard work already.
Because I got one son.
So it means you must do your will. All the anything that you must do your will. No will, then you make sure all the people is there. Let's say you got the parents, but when you pass away, your parents is still there. But no will, then you should make sure your parents will attend the meeting. When they hold the meeting to decide how to distribute all the people must agree on how. Then for those who got the money one, they don't care. They take some time, never mind. For those who need the money urgently, they will put a lot of problematic issue to this. To get you stable, to get you problems.
Because I got one sister already go for Singapore. No more IC. Singaporean already. So
Then problematic again,
better give up.
No will, then you have to prove that there's a birth cert, this is my father, this is my what the things. Then the foreigner now, they have to come in again to see the thing. 3 times.
roughly take how long?
3 times, depends on how difficult, how complex the matters. It depends. That's why this is a inherited problems. you don't let yourself put yourself into such a dilemma, whereby the property, if cannot be solved in future, they will be under the ban reclamation already. The whole.
Agak-agak lah. If like that, solve the thing, 300,000 can solve the thing because the land rate only 300,000. No more house lah already.
But they still the property still the value ma. Property in terms of the monetary value
only
sometimes compassion need ma, isn't it?
The ginger, only the land.
I need the
The
land, I
house
know.
cannot stay
But you
lah.
maybe upbringing you there, everything, since the children home is there, you see the land, like see your father or parents, maybe the value. Not in terms of the monetary value. Certain people, let's say, now just now the situation just now, then the executor say, certain people say, never mind, I'll sell it off. Then people say, no, this is the property left behind by the grandfather, then don't want to sell. I want to keep it, then how? Then quarrel with you. So someone wants to sell certain part of it, certain one wants to keep it, then how? This is the problem. So inheritance problems, inheritance property, you must be very, very careful. So to me, I suggested you do your view. So long as the view is there, then follow the view easier. Or otherwise, under LA, you have to call back all the people. Call back all the people to agree. Under view, no need ma. Under view, to A, M, B, C, and C, A, B, C. A pass away, never mind, beneficiary pass away. Who is your children? Come. This is your parent to you. You separate into the one third, finish. Isn't it? Under view, easily clear cut. But under the LA, cannot. The first thing, no will. You have to go to the court to decide who are going to be the LA executor, administrator. Who are going to be administrator? You say you want to do. You say, no, I want to do. I will. Fighting for administrator. Fighting to become the administrator. Also one of the issue. There's two parts, grant of the LA and the distribution order. So grant of the LA, court case already. He say he wants to represent. And I want to, every people want the power in hand. Then problem. Okay or not? So regarding to the inheritance property, take care. If you got the children, you got your family members or what the things, come to the certain age of times. But nowadays people pass away very young. So better do the view, better do your view.
Example, I heard people say, right, if a small, only one apartments like that, not much money lah. I think around 100,000 plus like that. So don't need to build, just go to Guasa. Can
Yes.
save the cost. You don't need because go to high cost.
Guasa, so-called the small estate, distribution of the small estate. So normally people call Guasa. Guasa nowadays, last time is property below 600,000. Now I think it's below 1 million over already. So it's under the small estate. Small estate, that means you can go with your own family member, you go to the land office, you can do directly the transaction there. Small estate can be involved when you didn't have your others property. Let's say you just own a house below the 1 million, let's say. Then you can fall under the small estate. But the question is that you didn't have the share, you didn't have other things, you didn't have the other property. Then okay, under the small estate.
Excuse me. How about if example I got 2 unit, total is less than 1 million?
Can.
But one title, one without title, master title.
Can. So long as the total value of the property is below certain limit of the things, then it can be considered to transact under the small estate. But the condition is that you must be the property. It means the house, the land, or what the things. Immovable property. But you don't mention about the shares. You got the shares, you got the stock, you got the market stock, what the things. Then you have to fall under the court order already. You must go to the court. For those amount above a certain amount, small estate cannot be handled, then you have to go to the court. Otherwise, we have to go to the court.
If banks still have little bit money,
You have to fall under the court. Land office, they have so the small estate, they cannot dispute the amount, the small amount in the bank. You still have to go to court. But let's say you get the 2,000 in the bank, then you engage a lawyer to get the LA, then maybe cost you a few thousand. So no worth to do that.
But how about the under master title land office can accept me?
They're going to do the agreement, the proper agreement. whereby the assignment or whatsoever things.
Who do lawyer do or
No, the land office one, they will do the translation of that. They may require the lawyer in to prepare some document, but normally the small estate, they won't let the lawyer to involve in that kind of the transaction, normally. So small estate means that you have to get all the beneficiary, then go to attend the one hearing in the land office there. So land office, the pengara there, they will give you the order. They can let you to transfer the property. Huh? Any questions?
If example parents is passed away already, but no death, so how to prove?
No. You might have a death cert. CJ kematian, you might have a death cert. Without the death cert, then you could prove that he has been passed away. You lost it,
So
you have to reapply.
Already?
You have to reapply, no? Like you lost a title, you lost an IC, then you reapply, no? You have to reapply, no? Okay? Okay, clear? So if clear, then we come to another part. We come to the tenancy. Tenancy problems. Tenancy is a more common to us. They are more in touch to us. So, third party claim as landlord. Why and how? When you sign the tenancy with the one landlord, suddenly halfway through, another people come to say that I'm the landlord. Then how? When you sign the tenancy, do you check whether he's the landlord or not?
No.
You do any land search or what to see that he's the landlord or not? No, normally we didn't do it. We claim that he's the landlord, then we believe. Isn't it? When you sign, then the town found that he's not the landlord, then how?
Normally agent will do
Huh?
we give a commission.
Let's say the property under father. Then the elder son, he may go to rent the property out. Then he sign on behalf of his father for the tenancy. The second son also like that. Everywhere declare that he's the landlord, but property belongs to the father. Isn't it? So normally for the small amounts, we didn't check it. For the big amounts one, definitely. Let's say renter is more than 20,000, 40,000 or what. We don't need to check who is the landlord, Either you are the registered landlord or just the beneficiary landlord. Certain of the landlord, they are not even put their not registered, but they got the beneficiary interest. Let's say A and B. Let's say A and B. Put the example you know. Put the example you know. Okay, my God. Put the example. Put the example, you'll get more clear picture. Let's say A and B. A and B. Landlord. Isn't it? But sometimes this is a landlord. So the moment you sign the tenancy agreement, both of them must sign. Right? A must sign and B must sign. This is a real situation. But always the dispute is not coming in when everything is go okay. Ordinarily business method, isn't it? Manner whereby we didn't clearly check all the things. But sometimes B may not be registered. He's the owner, but he got the 50% of the shares. B also got 50%, but B didn't put the name in. B is not the register, but he put the money to A to say that, hey, you hold on behalf of me, the 50% of the interest. So, they are no law basic, they don't know the law. When A signed the tenancy with other people, B also go to people to say that I'm the landlord. But he's just not the registered landlord, but he's a beneficiary landlord. He may sign the one agreement with A and B here, to sign the agreement to say that you hold on behalf of me, on trust of me, the share like that. So this is called the beneficiary owner. This is a registered owner.
Okay, if like that, I call my husband sign the authorized letter for me, can or not?
That depends on who is the owner. Lor.
Ada.
So regarding to the property land, especially the land property, it means immovable property. When you talk about the immovable property like a land, like a house, you cannot authorize like that only. The authorization must go through the PA, so-called the power of attorney. You cannot simply write the letter to say that, okay, I'm the owner of this, I authorize you to sign on behalf of me all the tenancy. You cannot be registered like that. You cannot be authorized your authorization like that. You must do proper way in the power attorney. Power attorney must be registered in the High Court. Must registered in the High Court. Then entitle you to sign on behalf of the owner. Or otherwise through the one simple letter like this cannot. For other things can like an attendance to the meeting or what I'm not free, please attend for me on behalf of me or what can. But for immovable property, cannot. Cannot. You got it?
Means like that I need to open the account two names together with my husband.
Supposedly, if both of you, husband and wife, is the landlord, then you should open the both account. For those the tenant, when they pay the rental, they must pay through the joint account of the landlord. This is the right way to do. But sometimes just for conveniency or what the things, we just simply pay to A or B. In future, if we remove the invisible hand come out, then there's going to be issue already. You pay to A, then B say I never receive your rental, no. Then how? This always be the issue whereby the invisible hand coming in. Okay, so third party coming claim as a landowner. To you is the third party, you know, but to them maybe he's the beneficial owner, you don't know. Isn't it? Second issue, can third party interfere the tenancy? Certain people, he now signed the tenancy with you, but without properly terminated the previous tenancy, he signed another tenancy with the other people. Then later on, with the second tenancy agreement, the first tenancy, the tenant coming in to interrupt the second tenancy. So this is called the third party interferes with the tenancy already. Isn't it? As a landowner, when you termination or whatsoever things, you must terminate it properly before you engage another tenancy coming in. If you didn't terminate properly, like SMP, halfway through SMP suddenly terminate off or the things, at least you should terminate it, revoke it properly before you sign another tenancy with other people. Or the SMP or what. Or otherwise, the party will come to interfere the tenancy. Then court case will be involved. Then compensation will be involved. Number 3 issue, why renter has to pay to the third party? Now I'm going to bring you this case regarding to the tenancy one. Why the renter has to be paid to the third party? Not paid to the landlord, man. But they declare that they are the landlord also. Sometimes. Number 4, why tenant be affected by the landlord dispute? If there's a two landlord, they dispute each other. You are the tenant, but you'll be affected, right? Why? Why? So now, I bring you, go through this case regarding your tenancy. I know that you all got a lot of tenancy problems, whereby in your mind, you have a lot of questions to put it out. But tenancy definitely is one part, it's a common issue, whereby all the while, we could own the property, we rent each other people, definitely we involved in the tenancy. So the tenancy must be very, very careful. Don't be all the while let the agents to prepare it. Certain of the things you must be very careful also. If we want to be prepared by agent also can, but at least you have a lawyer, friends, or what the things are to let them to go through it better. Okay, maiden chance confusions, our case. Maiden chance is my client. Pity her also. She got a lot of confusions. She just as a tenant, but there is a fight between the landlord there, but nothing to do with her, but she going to be the victim of the whole transaction. Okay or not? He confused what? Who is the real landlord? She's confusing who is the real landlord. then you can see that later on at the end of this story, then you can see that he's the victim, really he victim, to be sacrificed to fulfill the landlord dispute. No. Okay. Our actor, the main person is the Maiden Chang. This name I just created for you, it's easier to understand the whole story. I will go through it very slow to let you know the issue, because legally, all the lawyer they have the ability to identify the issue. You must identify the issue. What is the issue that they fight in the court? So Maiden Chang is doing the F&B. What is F&B? Food and beverages. So what kind of food and beverages? Restaurant, McDonald's, or KFC, or what the things are. When you talk about the F&B, definitely you think about the franchise. You think about this, 7-Eleven, Asia, this, that. This kind of with the branding, with the goodwill and the brand name. Or this kind of company, right? You think about this. But she's not doing this. F&B, she's not doing this. She's not doing this. Then you will think about she's going to do this, right? This also food and beverage, right? This is a more upper hand a bit. With the Western food or what? With the level, high class level or what the things? What do you think? F&B also. F&B also. But I tell you, unfortunately, she's not doing this. She's not doing this. She's not doing this. Then what kind of the business she's involved? She own a factory. She own a factory. She's doing this kind of the business. The F&B is regarding to all the utensil, providing to all the upper restaurants, high level, high-end restaurants, whatsoever the spoon, whatsoever the things. She are doing this business. This kind of the business, he involve a lot of the goods. Oh, 1,000 over pieces. So normally she need a lot of the very big space, the warehouse, to keep whatsoever the stocks. But I don't know why. All the while until nowadays, at that moment, she actually didn't own any factory. All the while she just ran for use. I just don't know why she didn't own any property. Actually, this is very important to her. I told her before. But I don't know why she don't want. She just wants to rent. She don't want to buy. She wants to own. She got money. All the money, she is buying the property. All the money she's buying the property, the real estate. It means she earned the money from the company, then using the money to buy the property outside. But regard to the business, the factory or what, she rent. Understand? She rent. Quite I don't know what she think in her mind.
Maybe you not approve.
Cannot be the company is so big. The renting the warehouse also not cheap, because she need the space. So she didn't own the factory. She didn't own, but she rents. She rent a few places. One day, come with the guy. I just give him the name. This is the name, landlord. The Amir Ismail. Just the name only. There's a landlord. So she want to rent the factory from this landlord, Amir. So definitely you have to come with the consensus. How much a thing, how much a price, everything. Go to the agent or what the things, talk about it, then see the space, see the warehouse, how big the space, then enough for the purposes or not fit for the purposes of the company to use it. Then finally agree with it. Tenancy sign, deposit pay. The term is a 3+3. 3+3. Render is a 20,000. This case is around 10 over years ago. So not cheap also. So render 3 plus 3 years and the 20K. What do you mean by the 3 plus 3 years? What do you mean by 3 plus 3?
After
3 year terms, 3 year renewal.
The first 3 is the fixed term. The first 3 is a fixed term. The second year is on the renewal basis. If you want to use the second year, then how? Inside the tenancy agreement, they has mentioned that the condition for renewal normally lah. So the first 3 years is compulsory already. Definitely, if I want to rent, you should rent it to me. But another 3 years, it depends on your renewal term. If this tenant want to enjoy the another 3 years, definitely inside the tenancy, they going to be mentioned about 2 months or 3 months before expiry of these 3 years, you should write in to the landlord to say that I want to use another 3 more years for this renewal period. So long as you write in, the landlord must rent to you, provided that they may increase your rental. So a lot of people, they fix the first 3 years for the fixed term, they fix the rental already. For this second 3 years, they also fix it by increasing no more than 10%, by increasing no more than the existing prevailing market rate or what the things are, they will put it there. Understand or not? So when you sign the tenancy agreement, 3 plus 3 means you have been already rent this agreement, this factory for 6 years. The first 3 compulsory is there already. Second 3 years is depends on whether you exercise your right to use it or not. If you forgot already after expiry of the 3 years, you forgot already to renew, then he got the right not to let you to use the 3 years. He ask you to move out, you have to move out. Understand? Huh? Get it clear?
Is it possible that tenancy don't have any renewal?
Yes, but that's why I say when you do it, this kind of thing, especially involve this kind of the renters by so much of the money, you should put it the renewal term by what the condition there, by increment how much you cannot be more than which amount. Or otherwise, this case very sad. That's all you can see. For the renewal term, they talk the money already. Then how? They increase a lot, no? Okay, So you see, key is handling over. Agree with the tenancy, sign already, key is handled, then deposit pay everything, renter pay, everything seems very good in this moment. At this moment, So you know that, right? When we pay the renter every month, I continually pay the renter to you. Tenants always have the one thing, quiet enjoyment. Quiet enjoyment. As a landlord, you cannot simply go to disturb her, Go to lock the door, cannot be like that, cannot do like that. Everything will fall under the term and condition of the tenancy agreement already. At this moment, you should let her quietly enjoy the usage of the demand premises. Okay, clear? So everything look like very good at this moment. Until one day. Invisible hand always coming into a picture until one day. When there's a one day, then something definitely is bad is going to be happen. Come with the one lady. One day, come with one lady. This lady say what? She say, let's say Mei-Ling, I give the name, let's say Mei-Ling, so-called Mei-Ling. She declared that she's the landlord also. She declared that she is the landlord. She says she also owns the ownership of this property. She say, she owns half of it. She owns half of the ownership in this factory, the warehouse. Definitely, my client, Maiden Chang, put a question mark on his mind, isn't it? What this happened? I signed this with the army already. How can you say that you are the landlord? Someone you declare that you're the half. Army own half. How can it become like that? She say, in future, since I own half, in future, you have to pay half of your render into my account. 20,000, right? Pay 10,000 to her. Pay 10,000 to Amir. Get it, huh? So definitely, Maiden Chan put a lot of question mark above his head. She can't understand what this thing happened. So the reason is how? The reason is that Amir now, the reason given by the mailing, the reason by the mailing is that she did before this, lend the money to Amir. Her story, the reason she give is that previously they did lend the money to Amir. Both of them signing one contract. Contracts being entered between them for lending this money. There is a personal loan agreement whereby this lady mailing agree to lend personal loan to Amir. Amir agreed to take out the personal loan. By agree that if I can't pay you back the money, you are entitled 50% of my factory or my warehouse. Understand or not? So she already put in a one private caveat on the property. It means Amir, can Amir sell the property now? Cannot. Why? Private caveat have been entered already. So definitely Amir cannot sell. Amir can rent, right? Rent, yes. Private caveat doesn't affect the tenancy directly. There's no direct impact there. Understand or not? So now she claimed that she got half because Amir charged his property, 50% of his property under the personal agreement to her. Can understand? So now he say, your money render of the 10,000, 50% you must pay to me.
You own the bank or not? This property.
I don't know. I think yes. I don't know. I don't know. I forgot already. But I remember that paper caveat is at nowadays under personal agreement, government is not agree for you to enter the paper caveat anymore already. But previously, all this can be done. Now, she said, okay, nice girl, nice lady, ma. Never mind, okay, understood. Since you say like that, I agree. Then she made a call. To who? To Amir. Definitely to Amir, isn't it? Hey, Amir, there's a ladies like that, coming to like that, personal agreement or private caveat, what the things are. He lent you the money or what the things are. Yeah, she asked me to pay the 50% of the rent to her, no. Amir say what?
Okay.
Amir take out the phone. Yes. Okay. Yes, you are right. Correct. Amir admit that. To say that, yes, there is a transaction like that. There is something have been agreed before like that. So 50% you pay to the to mailing. Since then, she started to pay the half of the render to mailing, and the other half he paid to Amir. Got it right? Got it right? So since then, half of the render paid to mailing, and half of the render paid to Amir. Clear? So this thing going to be many months already. Everything seems resolved peacefully? Yes. But there always more to the story. Everything seems like okay. Mailing come over to say that she own half of the warehouse, then she entitled to the half of the rental. Then our client Maiden Chan pay to both, 50-50. then everything seems like a resolved peacefully. But now, there's more story we have to resolve. Let's continue, continue. The facts. Now I come to the facts, Lawyer always talk about the facts. Now, I tell you, Amir and Mei Ling, both of them lend the money. There's an agreement between them. It's a personal agreement. Mei Ling put the caveat on it. It means the property cannot be sold anymore. At the same time, Mei Ling entitled to the half, and Amir entitled to the half of the rental, right? This actually is the problems between the landlord to landlord, right? Let's say landlord. This is a problem between the landlord to landlord. Nothing to do with the tenant. But why tenant want to involve in this? Problem, no, isn't it? Invisible hand coming out, isn't it? Supposedly, tenant had to tell the Mei Ling, I pay full to Amir. Amir owe you money, right? You get it from Amir. It's not directly, the money, the half of the rental should not be directly come from the tenant side. As a normal people, we won't do that. We won't do that. At the same time, at that moment, my client, Maiden Chang, she didn't aware that actually this lady, they come out to collect the half of the rental. At that moment, at that juncture of the moment, she already brought the case against Amir in the High Court of KL already. For recovery of the debt. I lend you money, you didn't pay me back, by the schedule, I say, fall behind the schedule already. So I bring the court case against you. At the same time, I go to see your tenant to pay half of the rental to me. Understand or not? This actually is a fact. Don't know. Maiden Chan don't know. They already in the High Court there, they already quarrel about the money. They quarrel about the agreement already. They fight for the agreement, personal agreement. Is personal loan agreement valid or not? Valid, Personal agreement is valid, Personal agreement is valid, so-called the friendly loan also is valid. But they are the interest inside. Can personal loan involve in the interest? No. Because you didn't have the valid license or you are not licensed to collect the interest, Only the bank, whatsoever the financial institution they may entitled to, but not you. So under the personal loan, normally it's free of interest. So interest cannot be involved in this matter. And second thing is half rental. Half rental, Our client paid half rental already to both of them. Not in the court case, entitled that. Court to say that actually they brought also Amir complained to the High Court. The judge here to say that she collect the half of the rental, for my tenant there. They brought it to the court. For interest part, we don't know because I think involved in this case. So judge, I don't know, but according to Amir, the judge say, no, she are not entitled to the 50% of the rental. He owe you the money, you lend the money, you owe you the money, you sue for the money. But you cannot go to the rental there to collect the rental, the 50% of the rental. So it means that the Mei Ling is not entitled to do that. Got it? So now, coming back to our questions. Coming back to our case. Previously, our client contact her. Now Amir coming back from the High Court. He say, hey, why you didn't pay another half to me for so long time? She said, no, I rang you up before. You say, okay, pay to who? You said this 2%, pay to this lady. Previously, I did call you, right? You say, okay, pay to this lady half. But he said, no, you still owe me half of the rental, 50%. You never pay me fully, monthly in full. I just receive 10,000, the half of the rental every month from you. You say I promise to you pay to Mei Ling or what? I don't know. Then how? Then now she put herself in the dilemma already. By the oral conversation, verbal conversation like this, how are you going to prove it?
No.
They're not even signing, you know, then how?
WhatsApp also they have.
Invoice bank come out. Invoice bank come out. He say, yes, lah, you told me that. No, I never receive. Then how? So angry bird lor. Pay the money in full every month, isn't it? Just to the different people, but now get angry already. Then how? See lawyer lor. They come to see me. Like that. Oh, sorry. This is the moment that I come into the picture. The first one, she bring along the tendency to see that there's a tendency between who? Amir and her, right? Tendency sign 3 + 3 years, 20,000 rental, isn't it? With Amir. Second, this lady, she say that she got a personal loan agreement with Amir, isn't it? So they are fighting in the court now, isn't it? The third, she say, I didn't rent before. She say, okay. He say, okay. The 50% of the rental pay to Mei Ling, right? Pay to Mei Ling. Then, now, he okay. Now, not okay already. Get it, huh? This is the fact at that moment. So, very sad, oh. How? A lot of money involved for them. What do you think?
Bank statement can prove that.
Yeah, but because through the site, but you are not the registered owner, ma. He's the registered owner, ma. Supposing you pay to him, let him go to pay another half to her, ma.
Because side agreement is between Amir, it's not for this lady.
Why you pay the another half to this lady? But you confirm it to the Amir. Amir say yes, okay. But you pay already. Later Amir say no.
Roti canai.
Now render she pay already. At this moment, render pay already. These two half already. All money taken by these two already. Half and half already. Render fully pay, you know. Half to her, half to him, you know. Then many months, you know. Not just pay for 1 or 2 months, you know. Many months have gone through already. Then half of the render, how? Now Amir asked for another half. You never pay me, then ask for the total amount. How to solve? This is the questions she bring to me. Let me know all the account, what are the things. So legal advice, what we can do? The first one is a tenancy. I say tenancy, now you got the problems. Since you got the problems now, to whom I need to pay the rental? Isn't it? Rental. So rental fully pay? Yes, she did fully pay the rental. But now rental to who? To whom she need to pay? Confusion. You confuse me already, right? So what should I do? I did advise her to say that you don't pay first. Because you're in the confusion now. You don't know to who the party you need to pay now. So you pay the rental to the legal firm. You pay every month, you pay your rental to legal firm. To my firm. Then regarding these two, they say half of what the things, never mind. Let them argue. We didn't bother it. We don't care. He say what, I don't know. But every month you pay the rental to my legal firm, I will write a letter to them. I will ask them to prove that you are the landowner, to prove that you are the thing like that, to prove that previously you say like that. I want to make all the thing into the black and white. But if you didn't pay the rental, they will say you didn't pay the rental, they will chase you out. But you pay to the legal firm to say that yes, I put my money into the legal firm already. Then every month, everything, money is there already. Then you better explain to me who is the landlord or what the things. Isn't it? This is a solution we can advise her at that moment. It's not a good advice, but this is the only solution. At least you can make she cannot pay the money anymore already. Now she pays to the Amil, then she will take the action again. She say, I'm the half of the owner. I pay to you, then you say, hey, you never pay me full. You pay me half only. Then how? Then confusion.
Pay to the Amil because the third party not in the register yet. The property not registered yet. And some more my tenancy is signed with the Amil.
Yeah, I know. But now she the tenancy is signed, supposedly to follow back the tenancy. But what she did is a wrongly did already. She paid a certain big amount to the Madam Chang already, the mailing already. Then how?
If Madam Chang call Madam Chang change the Amil that is.
Then now the only thing is you ask her to, hey, you get me back the money. Do you think she will get back the money? No, matter for this, it's not easy already. Then I want to let this Amil to feel the pain. I ask her to pay the rental to my firm, to let both of them cannot get any money. Then suffering or what, they force them to come and see us and explain to us. Then I through my legal firm write the letter to them to inform them. The renter is here. Can you come forward to explain to us who is the landowner now? You have to settle before us. This is the method lah. Even though it's not a good advice lah, but in practical you can see something at least.
Better than nothing, sir.
So letter out to Amil. I talk about all the story like that. Under the tenancy or what the things. Render 50% should pay this lady already. My client previously have been through the phone, call you everything. You say yes, but now you say no. So the 50% have been paid through the person that signed the personal loan agreement to you. 50% of the renter have been paid through the thing as you can treat this 50% as a personal loan. Refund the personal loan to mailing, isn't it? You can treat like that. You cannot discount our part to say that my client didn't pay. My client pay already, fool. Let us say like that. But he got the idea. What is the idea? No. I just want the money. Your client didn't pay me full. Your client just didn't pay me full. Now how? So now, court case? No choice. Bring it to the court. Bring it to the court. This is the lawyer represented by the Amil. This is me. Matter bring to the court. Prove all the document. My client have been fully paid already, like that. Amil don't care. He said that the portion you pay to Madam mailing one is not collected by me. I didn't receive anything. I just received the half of other things. Totally rejected the phone call. I've been proven the promise to the phone. So we go to the court. We fight all the things regarding this issue also, especially the 50% of the pay to this mailing. His lawyer also questioned about this. His lawyer also say like that. There's a personal about the things like that. My client never receive all the money from your side. Your clients like that never pay full. Argument. So I told the judge also regarding to the quiet enjoyment. My client fully pay, right? 50-50. Actually, she pay in full. She pay in full, But is there any quiet enjoyment? No. Every month you chase me cutting out because I never pay full, I'll chase you out. Then where is the quiet enjoyment for my client? Then I raise the issue of the quiet enjoyment at this moment. Then Sabina what? Sabina mailing to come over to testify as a witness to this case. You admit that you take the 50% of the money or not? Yes. Then you say that you are the landlord, right? My client paid the 50% to you, right? Yes. Then you say that you are the owner of the factory or what the things are? Subpoena her. Force her to come to testify as a witness. Then lawyer also argue a lot of things. Argue a lot of things. Then finally, okay. Finally say, okay, never mind. All cost settlement. Okay, my client accept that 50% only. Can. Okay, mailing take 50% only, never mind. Then the court case suddenly turned into the all cost settlement already. Okay or not? So Huh? Happy ending? Matter solved? Case closed? No. The nightmare has only begun. The nightmare just only begun. Not solved, huh? Let's continue. Another story again.
Plot twist.
Until one day, invisible hand emerged. I told you before, right? Term for 6 years, right? So now 3 years expire already. Then our client should do what? Write in writing 2 or 3 months before expiry of the first term to exercise the right to renew for the renewal. I want to use another three more years. First issue, Amir reject. No, you cannot renew. Amir say, you cannot renew. Issue, reject to renew. Can he reject? Can renewal be rejected or not? First issue. Second, Amir say, can. You want to renew also can. Lender, increment 100%.
40,000?
You want to use it or not can. Increase 100%. You see? Second issue. Amir happy, ma? See? See Amir happy face? Our client, sad face. From 20,000, increase to 40,000. Reject to renew. If you cannot pay me 40,000, then no more, another 3 more years.
The tenancy should be right, cannot increase more than how many percent? What?
Yeah, it should be supposed to depends on the renewal term of the
That's why I say tenancy might be careful. For the second term, any increment should not be more than 10% while setting all according to the prevailing market rate or what you should put it in. But without this, can no? They can put whatever the term they want. No? Tenancy is not the standard one, you know. You should apply it different case to case basis. So you don't always treat it like a similar. Then increase 100%. No. Never mention about the increase. If he mentioned that increase 10%, then increase 10% only, that's okay. But he never mentioned about it. Third issue, termination clause. Never mentioned about the termination clause. How to terminate agreement? Never mentioned. For reinstatement deposit, Amir say, you want to move out can. You have to reinstate back whatsoever the things that have been built before you renovate the thing, you put it back originally. Put it back in original way, original form. Or otherwise, I forfeit your reinstatement deposit.
In the tenancy conventions, this one.
Reinstatement deposit. Yes, there's a reinstatement deposit. You know that the factory, they use it for 3 years only. They lose a lot of money, you know. So big the factory, they ready now, they want to move out. The cost for moving costs, a lot of the renovation, everything cost you a lot. So these 4 issues. Then now how? Come and see me again. Actually settled in the court already level. But come to this stage, you come to me again. The first issue can rejection to the renewal? Can renewal be rejected or not? Renewal term, so long as you fulfill the first term. So long as you fulfill the renewal term regarding to the first term, the end before expiry of the first term, you fulfill the condition that 2 or 3 months before that, you must be in writing right to the landlord. Landlord should let you exercise the right to renew. Provided that you should put it there, the render can be increased or decreased to how many percent or what the things. But since you didn't put it in, they can increase 100%. I can rent to you 100%. When I argue this, rejection to renew, you cannot reject. Yes, okay. I cannot reject you, never mind. But I want to increase to the 100%. So second issue, they increase to 100%. You want to rent or not? Up to you. Third issue, termination clause. Now she wants to terminate, also don't know how to terminate.
But already expired it, what? The three
But
years?
but she had been renewed already under the condition. Yes, she under the renewal term. She followed the term. The first 3 years expire, but before expire, Maiden Chan say, yes, I want to renew. So she followed the rules of the renewal. Yes, she entitled to the renewal. But they didn't put the price to say that you cannot increase so much of the thing. Then landlord increase for 100%. Now, how? How to terminate this?
If like that, they are continue to rent.
How to terminate this? You say you want, I let you, but increase 100%. Then you say you don't want already. Then renewal how? Renewal.
Because you will never issue the 100%, but if like that, I also don't want to renew what.
Now then how to terminate this? You don't want to proceed, okay, maybe. But installment deposit how?
I don't want to give the
A lot of the
rental
money involved, you know,
control
that's why this is. So four issue does exist at this moment. So, nego law. At this moment, the only thing is a nego law. Previously, in the court, he said, yes, okay, 50% enough. Why? She will wait until this moment, especially of the first 3 years. When it comes to the renewal term, I put my condition in already. So nego. I talked about the renewal. He said no. He actually reject for the renewal. Then I said you cannot reject for the renewal because I will follow the term already. He said, okay, never mind. I increase for the 100%. He gives the idea again. He said, you cannot reject. He said, we cannot reject for the renewal because I follow all the term already. But he come out with the say, okay, increase 100%. This thing happened. Then renewal. This is a renewal issue. But my client say, never mind, renew.
100% renewal.
Renew. Okay. Finally, forced to. Because she really need that place.
Aiyo, so much
The cost for her to
money.
move out is very, very high. That's why she have to pay all this. So no choice. So factory. Then now see, same place, same factory with new tenancy or term another. Since they increase for the 100 already, they enter the new tenancy for 3+3 because they have to adjust because there's a no termination clause. So by this time, I prepare all the tenancy with her, then put out all the things to make the complete set of the tenancy. To make the tenancy completed, complete set. Then I render increase, no choice. So deposit pay or whatever the things. Render previously 20,000, right? Now, supposedly half. Previously render 20,000. He get half. So until one day, Mei Ling come over to say, where's my 50? Because Mei Ling didn't aware that the previous tenancy expired already. Mei Ling under the court allow her to collect the 50% rental. I may say, okay, she still keep on coming to ask for the money. But unfortunately, new tenancy has been signed already. She said no. Now she quite smart already. Know very well because she know that. Now she know that I did advise already. She's not entitled to law of this, so you cannot pay to her. Then now she's smart already. She tell all the story. Court order fighting this and that, go to the court personally. It's your matter, nothing to do with me.
Just like
Isn't it? So that's a court order already. So I don't care. This is your matter. So proposal settlement court order. Because court order proposal, what the things are is her matter actually with Amir is they are both story, nothing to do with our client side. So later on, she also I told her already. Then fighting. Then Amir cannot pay the money to her, settle the personal loan. Then this property under for sale now. Later on, she managed to get the court order under the personal loan. Then force Amir to sell this property to recover her debt. Because Amir didn't pay the money. Unable to pay the money. Then at this moment, she make a proposal, counter back to my client again. Why not like this? I rent to you term for 10 years. 3 plus 3 plus 3 plus 1. I mean offer you another 3 plus 3 ma? No, I offer you for 10 years. I'm not under the thing because I mean owe me the money, I got the call order already, I for sales. But I may pay me back the thing. If you can rent for it, I may not for sale I rent to you but I offer you the 3 plus 3 plus 3 plus 1.
Why she
10
want
years.
to buy this property?
She don't want to buy.
Double rental can pay lah, but cannot afford. the
Double rental
installment
is
lah.
out of her expectation. She did expect to pay for the 40,000. All the while she just managed to pay the 20,000. But she had been put herself in the dilemma. It be the conflict between the Amir and the Eileen. Condition is that I rent you for 10 years, 3 plus 3 plus 1. Why 3 plus 3 plus 3 plus 1? Why you cannot put 10 years? Why you don't directly put the tenancy for 10 years? Why you should put 3 plus 3 plus 3 plus 1? Why? Why? Why you want to put 3 plus 3 plus 3 plus 1? Why you don't want to put 10 years? Because any tenancy more than 3 years we are called lease. Any tenancy period less than 3 years we call tenancy. So for those who more than 3 years, so-called the lease, you should register your title in the land office. You should register your title in the land office. So by avoiding to register the title, normally title will keep by the bank. Because you still serving the loan to the bank, so original title keep with the bank. So you want to take the title out from the bank to register under the land office for lease. The bank not allowed normally. So 10 years, if you want to register for 10 years, then cannot be. Title cannot. So they do the tenancy for 3 plus 3 plus 3 plus 1. In order no more than, if you 4 plus 3 cannot, definitely is a lease already. You have to register the title. So you can see that no seldom lease normally people put the tenancy. So a condition over 10 years to maintenance time, at the same time advancement 2 year lender. You give me 2 years lender in advance. Then I rent you for 10 years. For condition
Rental how much?
40K.
I forgot yeah.
40K or 20K?
Lower. Then she said no. Because you fight with her, we fight with him, the court case, we still don't know the situation of this factory. Is it this factory? But he's the registered owner, but you're not the registered owner, but you got the right over this. But I don't know whether this, when can you become the registered owner of this? We don't know. Take times again. Then I told her, no lah, he said no lah. In this kind of scenario, you better choose the new lah. Move into the new office lah. That's really
2 years,
New warehouse lah.
300,000.
300,000.
Yeah, better move out.
Because the lady here, even though she got the right to record the debt, you didn't pay me, you charge the property to me. I can use this property for sale or certain street to recover my debt. But you still not the registered owner license. For the property to be registered under your name still take time. That's why therefore you go to rent this kind of property to put yourself in the risk situations.
960,000 is considered 40,000 times 24 months is 960 almost 1M.
But lesser. But she didn't see me at that last moment offer. She rang me up, she called me. She offered me like that. I said, don't, please don't. She very weak in decision making.
I buy a factory and rent to you.
Whatever 960,000 40K lah. Okay, half price are almost more than half a million lah.
You can buy a factory.
See, a simple tenancy situation. Just because of one mistake, put the 50% to the mailing. By calling to the landlord said, okay, no black and white sign. In my house. Call herself, you see, so suffering, you know. Had to engage a lawyer, go to the court to fight this and that. So be careful. You pay so much of the money, 20,000 per month. I say, why the tenancy you are not putting under the legal firm to do?
Save money lah.
This is the problem.
Because agent tenancy is more cheaper. What?
This is the problems. This is the problems.
This case is which year?
This case is around 2009 or 2010.
And that time factory price also not very expensive, she can buy also. I need to rent.
I just don't know why she don't want to buy. I just don't know why she don't want to buy. I don't know why lah. But bought a lot of the property without the factory warehouse. I say you should entitle to one warehouse because you are doing the business. All the ones belong to you, my list. Okay? Real case. Solution. Conclusion and solution. How? Is there any solution to her?
Move out.
In future, you must be very careful. Option to renew. Even though you have been signed the agreement for 3 years, but the option to renew clause, renewal clauses, you must be very careful. What do you mean by term 10 years? 3 plus 3 plus 3 plus 1 means the first 3 years, confirm, fixed term. It means they have to renew for 3 years. Let's say you rent the tenancy, halfway through, landlord wants to sell the property, can. Landlord can sell or not? Can sell because property belongs to the landlord. Definitely landlord can sell, isn't it? Sell to another party. But as a tenant, you now still within fall under this period, the 3 years. How?
Continue.
The landlord supposedly should get a new purchaser coming in to talk about this. Either you sell the property together with the tenant or not. But if landlord sells to a third party, new purchaser, just let you be like that, they can sue the landlord. Because tenancy, you say rent me for 3 years, but halfway through you sell it to other people already. I can take the action against you. Isn't it? Affected my interest because otherwise the new buyer coming in, let's say new buyer coming in, he bought the property for the landlord, new buyer coming in. He can chase you out or not? Can. Unless the previous, the SMP there mentioned about you buy over together with the tenant. Or otherwise this new buyer can chase you out because nothing did with you. You didn't have the agreement with him. Whatsoever the agreement that you signed the tenant is with the previous landlord. You sue him, you can chase you out. So normally our protection under this term is novation agreement. Novation agreement. Whereby the party here sit down, seller, the landlord, as a seller, new purchaser coming in, try to sign the novation agreement to say that yes, I signed the right to this guy. In future, I'm dealing with him. The old tenancy still apply, but now party differently. New purchaser sit into the shoe of the previous landlord, previous seller. Then the right is assigned to this party. Then okay. Then for the second 3 years and third 3 years and the following 1 year, this is depends on the exercise option to renew. It means doesn't I can give you 3 years, but doesn't mean that you are entitled to, but you must follow the term. Before expiry, normally it's 60 days, 2 months before expiry of this, you must be in writing. So all the while, 3 years, you don't wait until the last 2 months, normally 2.5 years. 2 or 3 months before that, you have to write a letter to the landlord saying that I want to exercise the right. for another 3 years, he has to give to you. Because he has been promised you already. But other condition, there's a condition. Option. You should exercise your option. You didn't exercise, then no more. But 2 months before the expiry of the first term, you exercise. Yes, I want to rent for another 3 years. They have to give to you. They have to. But subjected to the increment of the rental. So normally inside here we will say for the following term 3 years, or the 1 year, we put it here. Either increment by not more than 10%, or you follow the prevailing market rate. You have to fix a percentage of the increment. Or otherwise, we say 100% increment now. For the 20,000 to 40,000 already. Huh? Termination clause. In what condition that the tenant or landlord have the right to terminate the things? Right to termination, landlord and tenant. Clearly certified, clarified inside the tenancy. Why? Because all the while people treat this tenancy as a very common thing. So copy and paste until the termination clause that disappear already. Also did amend. This is a problem. So for the big amounts, normally engage a lawyer to wait. For the big amounts. So, any questions for tenancy? Any question for tenancy?
Okay, if tenancy, I can mention, if you never pay me the rental, I can entitled to go in your house inside.
Cannot, because unless you have been mentioning into the tenancy.
Yes, I mentioned in the tenancy.
Yes, in case in future you didn't pay me the rent, I got the right to re-entry the premises to whatsoever thing like that. Yes, book party agree there. But normally as a tenant they won't agree on that. They won't agree on that.
And if they are agree, so
If they agree, this is okay. Tenancy is not standard one. Depends on the
if they
book
are
market
agree,
people.
I break in, need to make the police report everything, so not.
For whatsoever things better you go to make a police report first before doing this, because in future trespass, people may call it trespass. Or they may say re-enter the things is very risky. Because once they involve the court case, they may say that they lost out the stock or certain things, they ask you to compensate. No? Like the case I mentioned about the market one, the mini market one. Then the tenant ask for the compensation from the landlord. He compensate all the things, you know. When you lock it down for 3 or 4 days, discover that it's been longly concealed, then have to reopen again. All the fish, everything inside there all spoiled, you know, then have to pay compensation. I think I forgot the amount already, 300 or 400, more than that.
I want to ask, just now you say how to freeze the main door. I can't understand. The supermarket. Why? Because they only have one main door,
Supermarket, that's why I tell you, supermarket is a bit different story. Whereby supermarket always they rent for the many units, but not owned by the one owner. So supermarket normally involved in a few units. So let's say this is the places rent by the someone to do the mini market. Normally they will take the tenant A, landlord A, or landlord B, or landlord C, or landlord D normally. So when you sign the tenancy, you will sign the first tenancy, second tenancy, third tenancy, and the fourth tenancy with the different owner. After that, mini market, right? Definitely they didn't have the many entrance. They definitely will put the one unit as an entrance, right? Then the signboard was suddenly they put it here.
Yeah.
But the whole unit they will conceal out. They won't let people simply go in and out for these other units. So this is the main entrance of mini market, isn't it? So when there's a dispute among all the landlord here, especially this one, let's say he gado with this one, gado only. Then now, but he still paid the rental to these 3 persons, you know. He still paid the rental. But this fellow are happy, he goes to court to get the distress order. Distress order to conceal the unit. But now when you conceal, you just can conceal your own unit.
But
you cannot conceal the unit here. But now normally when people come over, they see this company will be like that, they will consider entrance. Not the entrance.
So
Then after 3 or 4 days, discover that something happened like this. They quickly go to reopen. When they reopen, mini market, you know that inside the flesh, you process the flesh, seafood process the thing, all spoiled already. Then you should compensate law. As a landlord, rent the unit to the tenant. At the same time, as you compensate the tenant for that. So even though there's a fixed order, you must be very careful.
If like that, suppose how to freeze the unit, no door.
If you found that this is the unit, at least you conceal here, inside there, you go through inside here, you seal the unit here. This department you cannot enter, this one you cannot touch.
Means you must go inside to.
But as a occupier of this unit, I will say, hey, I will not allow you to go into my unit. So you cannot conceal this unit, no easy to conceal this unit.
So
Not easy, no entrance, no entrance. You cannot use this unit to come in because I'm not welcome, you are not welcome. Isn't it? Officer, enforcement, and you are not welcome. Then how? You cannot go in here to enforce here to kacau my business, you know. You kacau with my business already, you see. So cannot conceal lah. But this landlord, he forgot about this. When you get the enforcement car, they lock up this the entrance, then no problem already. You have to compensate the whole spoiled things inside here, you know. Then of course settlement, pay the money.
this case how long?
This case not very far, not say how long. This case very fast. This case around few months only, 4 or 5 months.
Then the landlord to pay the tenant.
They not to pay.
How much? You still
I forgot the amount, but 300 or 400 like that.
300 or 400.
1,000.
The rental outstanding is how much?
I forgot. This case around in year 2000, 2010 like that.
But if tenant after tenant move away already, then he do a lot of damage then more than the deposit already. Then how the landlord gonna chase back? We don't have any way to chase back.
Same thing. When the tenant will keep the places, demand premises, you find that he spoiled a lot of things, whereby the security deposit is not enough to recover the repairing. Then the rest of the amount you can sue him under the civil suit. Legal case, put under the civil suit. Okay, Okay, the final part is regarding to the engagement of the lawyer. We, as a ordinary man, you should know the function of the lawyer. Why all these things happen? Because previously when they do the decision, they are not get the consultant. They are not even consult with their own lawyer about the things until they really facing this kind of the unnecessary but so-called invisible hand doesn't exist. If they did like a maiden child, previously something happened. Some may come over, say that he entitled to the 50% of what it is, you better call the lawyer first, isn't it? If he, at that moment he didn't call the lawyer, I believe that this case is going to be so complicated, isn't it? So ignorance is not the excuse, ignorance is not the defense. So engagement of the lawyer, you should know that lawyer actually separated into two parts, so-called the advocate and solicitor. Advocates certain areas, that certain countries they call it barrister. Barrister in Hong Kong, in UK, or they call it barrister. Because barrister is the lawyer attendant to the court. At the same time, solicitor it means the lawyers know to do the paperwork, SMP or what the things. But in Malaysia, advocate and solicitor they merge together. But in Hong Kong, in UK, they separate up. Or either you are the solicitor, either you are the advocate. For those advocates, they seldom prepare the document. They just attend to the court only. Document prepared by the solicitor. So in UK, when you engage a lawyer, you should do both. One solicitor prepare the document, pass it to the advocate to run the show in the court.
Can join together or not?
Malaysia, you join together.
How about the Hong Kong just now you say?
So that you engage who, no? Engage the lawyer to prepare all the divorce documentation. After that, you to employ another one to present you to the court. So normally, solicitor will advise you who is the advocate have been dealing with him all the while. They're familiar with that. But in Malaysia, we didn't have such a problem because advocate and solicitor normally we merge together. But why they want to separate the two? Because the advocates they save a lot of time. When they know the court procedure, everything normally will save a lot of time, court time. Otherwise, the solicitor goes to the court. You don't know this and that, waste a lot of time. Lawyers, even though advocates, solicitors, you have to see the license. They graduate from the title so-called the LLB. Certain of the lawyer they didn't have the LLB, they come with another different title also, so-called the lawyer. So must come up with the title of that LLB. Graduate from the CLB. At least you have been certified by the Bar Council to say that you are the qualified lawyers. So CLB is a Malaysian Bar Council exam. Then diversified. Lawyer should be diversified every corner. It means you cannot be straightforward like this. Don't know how to argue over the things. You should, when you engage a lawyer, you should make sure that they have the LLB, CLB, all diversified themselves in what kind of angle. At least they can cover yourself in future. Don't choose those who are the straight-minded like that, cannot turn everything like that, and you got the difficulties. You should know, you should take care of this when you get engaged with lawyers.
I know. How I get the lawyer?
Then you should all the while recommended by friends to see how for this experience. Personal experience. Certain lawyers they didn't have the experience. Not enough experience about the things. You see the experience. Final one is the problem solving skill. Now facing the problem, how to solve. You see, when the invisible hand come out, the problem solving skill going to be the very, very important skill already at that moment. To see whether what kind of good advice that the lawyer can bring to you. Or otherwise you may lose the case. We lose the case, some of the time you lose the case not due to the chances, but you due to the technical part. The technical part, your lawyer not good in the skill, not good in the technical part, you lost out your case. Not due to the reason, not due to the argument. You may lose your case not due to the argument, but technical. Certain things, document must be found within 14 days, but your lawyer forgot. Then how gonna do you lose the case? Certain cases lost like that. Second things, you should know the personal legal representative. All the while anything happens in this legal aspect world, we should know very well. You should sometimes the legal part you don't know all aspect. You should get your representative to represent you. So the first thing, the lawyer should be fully protected you in the best interest. You cannot engage the lawyer whereby he cannot protect you, or you can engage the opponent lawyer to protect you over the things. Better you choose your own, protect yourself. So you should know the lawyer very well. Second, to get a clear advice on your legal rights. The first thing, as a tenant, what should I do? Or what should I do? Before you take any action, make the decision making, you better get a clear advice from your legal advice. To advise on the effect on your action. Now like a middle child. Before you take any action, you better to make sure that when you pay the 50% to Meili, what is going to be the consequences? You cannot just by the promise by Amir to say that yes, okay, then I thought you pay already, then this is a problem already. To avoid being cheated and manipulated by someone. Tell you, lawyer also human being, he can cheat you also sometimes, isn't it? So manipulate the facts. Finally, to feel secure and to be in peace. When you feel something not secure with the lawyer, change the lawyer. Change to those who feel more comfortable. Lawyer responsibility. As a lawyer, they know very well. Lawyer by profession, they know very well to help those who be should retain services. You retain the lawyer should be protect you in the best interest. Lawyer will be presented due to the duties. What you want me to do? You engage me, I will do it for you. So normally one lawyer for one party. You cannot represent this party at the same time you represent the others. So just like a lot of people, you use available lawyer. free, right? Free legal fees, everything. Like use a developer lawyer. In case something happened already, this lawyer is appointed by the developer. So your interest will be undermined at that moment.
But developer not allow others lawyer to do the S&P.
So this depends on the thing. If you're not allowed, then I'm not to buy it. Supposedly, you got the right to engage your own lawyer or not to do it. No. So S&P, because under the developer lawyer free, isn't it? Free or legal fees. But under your own lawyer, they charge you, isn't it? But supposedly, the amount is big. You should engage your lawyer at least come in to check or the document. Engage your lawyer to come in to read for you or the documentation. It's okay, huh? Then to uphold the bank interest, lawyer should uphold the bank interest of the client. Lawyer not to disclose any personal information. Let's say I know everything of your personal information. I cannot simply disclose that. Then no personal benefit. Okay. Certain lawyer, you know that this piece of land that go to be sell what the things are under the price of what the things are. Lawyer may get you out of the picture and he go to buy himself. This is the thing, no personal benefit. But this thing is protected by under the Legal Profession Act. Like this 76, Legal Profession Act protect the lawyer. Then even though the lawyer is a human being also, they can breach their duty, isn't it? So you may complain to the bar council. You can complain to the bar council. You can disciplinary board will take the actions. In case there's a lawyer misconduct by the lawyer, disciplinary board will take the actions. Actions normally will go to be strike out the role, and the strike out the role or suspend for the practicing for certain period of terms. Okay or not? So engagement of the lawyer will avoid you, not say 100%, but I tell you, a lot of the high chances you can avoid yourself from this kind of thing in high situations. Any questions?
I still want to ask, how about the electric and water bill? What I can do? The tenants never pay for 6 months electric bill.
For tenancy, tenant don't want to pay the electricity and the water.
But it's under my name.
Yeah, under the landlord name, then landlord you can apply to the authority to cut off the water and electricity. But certain of the tenant also smart. They go to borrowing the electricity and water from the neighborhood maybe. But depends on the situation. But you as a landlord, you got the right. You cannot rent the people without paying the rent. At the same time, you are entitled to stay inside. At the same time, you are entitled to water and electricity without paying them. Only to them. This is something wrong already. So you are entitled to, at least you have to complain to the local authority regarding this to cut off the things.
Can I complain to the TMB? Why my deposit is 300 but their deposit example is 300, their own around 2,000, 3,000, they are still TMB still giving.
This is the local authorities. This is the local authorities. So important thing is that why they didn't cut off, even though they are more than the security deposit as been paid by you to them. This is the problem because they are a human being also, isn't it? They should remind, at least put the letter in, let them go to trial and sign. At least have been notified to you already to say that cut off, deposit so much only. Let's say deposit for 300, but what for you go to let it the outstanding for 2,000 or 3,000, isn't it? Put it in the letter, send it to the Shabas or the TNB, let them try and sign back. At least in future this is different.
The tendency, can I add one more clause is you need pay more than 2 months electric bill, I can cut off. Can I put in the tendency to
Tenancy, so long as there is a agreement between the both parties regarding to whatsoever terms, acceptable. So long as the both parties agree, agreeable. It means both parties can come into whatsoever terms that can be agreed. Even though he come with a 40,000, this is 40,000, but my client say okay, then agreeable. Nothing wrong, isn't it? It depends on the necessity and the legal power of which party they have more.
how much you charge the bill?
Will normally is very cheap. No, will normally is one property or one car or certain things. Will normally we come up with the 500 or 600 per view. So normally to pay higher, normally to pay a lot.
Because Rockville doing like 1,000 plus like that.
Because they are the professors already, they got the commission for agent everything like that. So
I want to ask,
The-
Rockville is better, do the will is better because either is lawyer firm.
So to me, unless you are very rich, or otherwise you do the will in the legal firm better. Because they can put whatsoever they because the lawyer fighting the case, they know very well whatsoever the loophole, all the things of the case. Then they will cover you under the will. But if you go to the law view whatsoever they do profession like that, they every courses they will calculate with the money. So you are not so rich or what the things are you want to save the money or what you may not want to put in deal so many to you is unnecessary clauses. But in future it does really turn into the very important. Then how? This is the issue.
But lawyer firm never keep the will like Rockville, they can keep for until you dead that time. Lawyer firm got do that.
Yeah, legal firm to keep the documentation for 7 years.
If
You
more
should
than
keep the will for 7
7
years.
Ah.
But law you should pay for keeping. But legal firm normally they keep it for they ask for the keeping fees. Okay. Any questions? You are actively involved in the questions. I found that's very good. At least you got something to ask, and then you can get a more clear picture. For the today course, I can say that thank you for coming, and then I hope that you all really can get something back, and then something that very helpful to you, especially in your career or your profession. Then at least in future, try to avoid this. Try to avoid this the invisible handicap situations in your life. You should know that certain things you see, either the first case and the second case, you can see that the Indian boss and the Maiden Chang, they didn't expect it, The Indian boss, they will think that I did the will already, everything will go to dispute under the will. But he didn't expect that the Gandalism will come in. Gandalism, right? Even though their team, the management team, won the case in court, but come to the other day, in fact, if now he knows about this, where I truly believe he will be very sad. The son is not the party he wants to dispute the money, but 70 or 80% go to the other already. The company, he wants to see the going out of the company, but that company gone already. Close out the door. See? This is not something that the deceit vicious. No respect for the people who pass away. So to me, you did expect that even though you did the right things, but come to when you carry out the things like a Maiden Chang, even though you sign the tenancy behind you, everything is so good, but suddenly come up with those who come in to say that you are the elderly law, what the things suddenly make you yourself make a wrong decision, mistakenly make a decision, then you are facing a very, very painful consequences. This is the problems. This is the problems of the invisible hand. This is the purpose why I bring over my case. The case I did handle before, in the past year. I try to bring it into the picture of you in the layman term, in the very plain term, in the picture as simple as like that, to let you all know the situation, the real situation, and the scenario of the real cases that really happen in the nation, in our court. In true case, whereby the people, they actually can avoid all this, but just mistakenly did something wrong, then involving a lot of things. If the Indian boss previously inside his view to say that I want to pass it to my management team, all my children cannot be entitled to like that, all my wife cannot be entitled to like that, clearly stated inside the view there, isn't it? But even though they won the case already, but the Indian boss, he didn't expect that they come with the gangsterism. The gangster come over to tell you for the business, for the daily business, until the business cannot be carried out anymore. See, he didn't expect that. So law is not everything now. But you know law, better you are. You don't be you stuck yourself into this kind of the unnecessary situation. You got it?
Yes.
So hopefully you all get something back today. So very soon we will go to arrangement another courses like this. I maybe bring over more cases, more real cases to you. At least you go through this kind of real cases and you can see the more entry scenario. Even though I left it out a lot of the legal part already, inside content, a lot of the documentation, a lot of the argument, I leave it already. I just leave the main issue only to let you know, for you to have a better understanding. Okay?
Okay.
Okay. Any questions? So thank you for coming. Thank you for joining me for this about 4 hours courses. Thank you.
Thank you.
Thank you.
Okay. One more thing. I forgot. Be seated. We still have the one more session for discussion session. So I want you all sit around here, face to face. Then you have a discussion. Try to discuss something that what is your outcome of the you have learned from this course, and then what kind of the issue that you want to bring out. To me, discussion maybe you can discuss about the low rental, the small rental, whereby you are unable to engage a lawyer or what the things that maybe you all encountered before, right? So I think that this is a good time for you to discuss it. So be seated, you have to discuss about what have you learned from this course and discuss about the issue of the tenancy or what. Up to you all. Come, be seated. Some of you sitting here. So the discussion is up to you all. It's free and easy. Yours, anything you can share among yourself, anything you have learned from this course, anything you can share among yourself and you can share it. But the important thing is that I can give the hint to say that there's a small amount because this is a very common issue in the market nowadays. Okay, let's discuss. This is your time.
Okay. So any problem you guys encounter during tenancy period?
Like I have one apartment, rental only 500. They never pay for me around 6 months like that. I straight away cut the electricity
Okay. Electricity under your name?
under my name.
Under your name, you go cut it.
Cut off. Go to TME. Say I want to cut off. You done before the
You never pay for 6 months.
6 month
You
rental.
never pay for.
The outstanding TMP around 800 plus. Also never pay. The deposit also cannot cover utility. So I straight away cut off the TMP. So now normally I call the tenants straight away apply themselves. I don't want apply by my name.
Safer lah that way.
But if tenant apply the TME by himself, then under his name, then what is the consequences if they don't pay for it? Maybe they own about 10
TMP
houses.
sue them, not under my name. If under my name, it sue me.
They'll find whoever make the account.
I say these tenants already run away, so I just want to cut off the electric. I will call the new tenant to apply themselves. The TMP allowed lah. So minus the deposit, the balance I need to pay.
But residency can do change name for the TME.
Can authorized letter and tenancy agreement stamping. But only the tenancy agreements, they need to stamping first. So an authorized letter passed to the tenant apply themselves already.
So if the situation is like this, if master owner he rent a sub unit to another people, which means he already tenant to another people lah, and then the tenant itself sub rent and to another third party. So which means he become a sub
Sub-tenancy.
sub owner lah, sub owner lah. So if like this example lah, if sub owner with the latest tenancy is around 2 years the tenancy agreement, but then he with the master tenant only 1 year, then how come result?
That one want to ask lawyer.
This is the problem. This is another invisible hand case, account. Because you cannot give something that you don't have, right? So since you get from the first owner, you get the 1 year tenancy, you cannot be offer the other for your another tenant for the 2 years. That's why this is wrong.
Then how? Then the final tenant will be.
Then the final tenant, then they will come in to sue the second owner, the second landlord, the sub landlord, because you sign the agreement with 2 years, but actually you get it from the original owner for 1 year, then there's another 1 year difference. That's why he can sue you.
But then the tenant can continue to stay inside or not?
No.
Cannot.
No, cannot.
So if the master tenant say I don't
Primary tenancy and the secondary tenancy. Primary tenancy say 1 year, secondary tenancy say 2 years. Then the subtenant is a third party coming inside already even though there's a 2 years, but the original tenancy they didn't have a 2 year for you. So you have to move up. You can sue for the sub landlord.
But the if the sublandlord have taken the deposit this and that, they got the right to take the deposit everything, right?
Yeah.
They have lah.
If they want to stay back, they can sign the new tenancy with the original landlord. Then take the action against the sub landlord. This is the way. This is another case like this. Good for you to discussion. This is another invisible hand cases.
Because my friends got one case kena lah, 230,000 outstanding from TMB. 230,000 TMB.
It's mining case, is it?
How do you not cut the electric?
I also don't know. My friend also.
Because you're under labor already.
Maybe lah, but 230,000. But lucky it's not under his name, under the tenant name. So the TMB will sue the tenants, but TMB already tell my friends, if the tenancy agreement is over, but they are still continue to use, that one is under the tenant, under the landlord, sorry. So you also need to pay the risk.
This is the best way whereby the tenancy, the TMB will be under the tenant, their name, Not but the Shabas, the IA, the water is under the landlord, normally the owner. So it's good lah. It's good lah. At least the outstanding is up to the tenant to pay or not lah. But it's not good for the landlord also because there's a the bad call on your unit, But now I want to raise a case with you lah. This is an investment case also, whereby just like as I mentioned before, regarding the small amount of the rent. They owe you 6 months, maybe 1 month 500, they owe you 3,000. But the important thing is that you engage a lawyer 10,000 to sue him. So how?
I cut off the electric lah.
Cut off electric may not be so direct solution, because a lot of the humanity issues, due to the humanity issues, sometimes they may not do that.
I tell the TMB, the tenants already run away, so I just want to cut off the
When they approach the premises, then there is some people staying inside, they won't cut off the thing due to the humidity factors.
But they already own a lot, then they maybe
They don't want to move out. They don't want to move out.
and take out order.
Take order. Yes, this should be the way, but you have to pay 15,000 or 20,000 for the things. You have to pay more.
1 year only 6,000.
It means no work for you to spend so much of the money to recover the thing, get a court order or what to recover your unit. So what should you do? What should you do? Invisible handmade matters.
Everyday go there lah. Make noise.
Can I change the law?
No, this is the weaknesses lah. This is the very the loophole in the law lah. The enforcement of the law is too expensive, too costly. Until you amount of rental you collected too less. For you to do
Whether
that.
I can say in a tenancy agreement, if outstanding more than 300 example, the tenant allowed me to cut off the electric, give me the
No, TMB now they didn't bother, but the TMB also got the humanity issue. That's why I told you already, they won't cut off. They let it be lor, they just
because
inside lor,
it's
you don't pay the
under my
rent.
name mah. The property is under my name mah.
Yeah,
The
you
TNB is-
how do you chase them out? Ask them to move out, how?
Give them pressure. Send a morning message.
So I
Why
was
to chase them out?
You're facing this kind of problem before now?
for me have lah, but I straight away cut off the electric. Lucky the tenant TNB helped me to cut off.
You go there to collect the land, the children crying or what to say that they got no money to pay them.
Don't hear lah.
Move to another cheaper place or
Unless you
500 already cheaper lah. What kind of property you want less than 500?
there's a case I handled before is you have to engage, you have to locate for the one new place for them, engage the lorry coming in to move the house for them.
Wow.
and you pay for the land.
Pay all the other costs. This is the one of the cases in Kampong.
So Singapore.
Normally the cases like this you will advise them go to launch a police report. You will launch a police report first to say that actually this is under the tenancy, under the tenancy, but at least I launch a report for that for not passing or other things. Second thing is you have to take the legal action, issue the lawyer letter to them to say that ask them to move out for 14 days or other things. If they cannot do that, then you have to serve the letter, definitely serve the letter to them. Then you have to get the police or other things go to break and re-enter the premises. Then chasing out. This is the only way. But they will sue you. But this kind of method, or you can lock the thing. You launch a police report, you with the police matter, you go there, you buy another lock to lock the premises, lock that, make sure there are no people inside. Then you should lock the thing until they cannot open it, they come and see you, then you ask them to settle first, ask them to move out. Or otherwise, you have to, no, definitely they will say, tenancy, I owe you the rental, right? But you cannot lock because I have that quiet enjoyment. I've got the quiet enjoyment, you cannot simply chase me out. I owe you the rental, but you cannot simply chase me out, So I got the quiet enjoyment, they can sue you back, if you want to. So the better like this is you get ready to be sued
But
you
few
got
hundred
the-
also cannot pay.
But you got the lawyer letter and you got the police report at least to cover yourself to facing that in the court in future.
Few hundred also cannot be paid. How can they get money to pay your legal fees?
I don't know. But this is the invisible hand matters sometimes happen also. You all discover anything or not? In tenancy?
If
But just now the sub-tenancy is a very good case, sub-tenancy. You cannot give something you don't have. You can get it from the original landlord for 1 year, you cannot give to the other people for 2 years.
It's most happen in the college area.
Huh?
University area, they suck the room and rent out for the college student.
Then they try to collect a lot of
yeah,
deposits
Subang that side got a
from
lot.
a few parties.
Subang
Then-
somewhere.
Because some landlord can collect the deposit and the utility everything from the another tenancy.
One unit or house, they want to separate to how many rooms, they want to make it into how many rooms. It's a banned by the law, So you cannot simply do it,
Then that's why they cannot do the tenancy agreement, but they can still collect the fees for it.
Well, my friends are in somewhere. One condo can stay for 10 people.
They convert the living room to the room, is it?
Yeah.
Separate room. Nowadays Singapore also like that. They also convert the toilet also.
But can tenant,
Kitchen.
my friends can go in because he rent a room or place only, but not rent the house. So he also can anytime go in to see any things to break off or not.
Okay, try to say something. Okay, very good. You always issue, but try to say something about the cost. Invisible hand. What do you really learn or realize that? You know the danger of it or not? You see the risk.
Yes.
Yeah. So in future, how or what the things? Say some words.
But eventually, if we face this kind of problem, right, we still cannot fix it because like the small amount, right, we still cannot fix it by our own. We still need the legal advisor, right? But then how as an owner to protect itself, if a lot of things happens, like a lot of unseen problem what you call.
Definitely, because amount too small, it's very hard to enforce.
Yes.
But no matter how, once you encounter this kind of problems, you should put the legal as the first. At least you lodge a police report, you issue a letter first, then you do something that you want to do.
Like example, in my tenancy agreements, I just mentioned if you never pay for 2 months, you allow me for break-in. You give me the
No, not say break-in it's a re-entry re-entry. You can put like that but tenants may not be accept Now market is so slow isn't it? So every people want to rent the property out.
Is it possible to put maybe interest or anything inside the tenancy agreement?
Can, it's allowed. A lot of people say for the area of the rental, I can charge you 8% per annum or what the things can.
If you doesn't pay or anything.
can charge the interest
Okay.
until how many percent? 10%,
18%.
12%?
Normally 8% per annum.
The highest?
No, 8%. You want to charge for 1.5 per month. 1.5 per month is very high already.
1.5 means
Per
1
month
year
as for
18
commercial.
18.
Commercial. So normally to be safe, you put 8% per annum. So, Nick, you got anything to say?
I'm just thinking if since we're talking about will and then we're talking about tenancy, I'm just trying to ask if we can put tenancy into will. Like if I'm still renting houses when I'm passing away and then I'm drafting my will, can I say I wanted to pass this tenancy to whoever?
Very good question. Tenancy under the will. To me, yes.
Yes lah.
Tenancy can be. Because under the will, when you pass away, the executor is very powerful. He will sit into your shoes to represent you to do what sort of things. So your tenancy under your signed by the deceased will still carry on. So the executor will come in to executor, carry out the obligation under the law.
If the executor take the money but never pay me, so
Then you
I
can sue the
remove.
executor. Then you can sue the executor. Unless you have the proof, you can sue the executor. So actually, the purpose for today is I want you all to see that the invisible hand, the risk of the invisible hand, something that you cannot foresee. You cannot foresee. Something that it can't be that unexpected. Suddenly something come out, nothing wrong with you, nothing wrong with him, but suddenly the case cannot go through. See? So you see the case like Maiden Cham or what, like the Indian lady, Indian boss, it's a very sad case. He did the will, he want to pass all the things to his employees, but his net of kin coming in, his son and children coming in. Then there's a court case already. Waiting a long time, spent a lot of money. Maiden Cham is a very sad case also. They write the tenancy of the suddenly come with another landlord coming in to say that she's the landlord also. Because there's a problem with the landlord 1 and the landlord 2, right? So she start into the matters. Then unfortunately, she actually did not handle well did not see the legal advice. See the legal advisor before tenancy being signed. So she also don't know how to get the renewal of the tenancy. then until people can force her to increase for the 100% of the rental. See? So this is a very sad case. So the purpose for you today here is to try to see the risk and try to avoid in future. Don't get yourself into this kind of problems. Especially in the property transaction. So learn something?
How about if example lah, my renter, I passed away already, my property want to pass to my son, but the renter I pay to my husband until my husband pass away, only the renter pass to the son.
This is a conditional. This is a conditional view. Again, you can put the condition into your view. Okay, so anything? Just to say something? So I want you all to see this, to learn this. Actually, the key of the risk.
We sign a contract also got hidden issue behind.
Yes.
So we have to.
So anything in future, see your legal advice. Seek for the legal advice first. So if you're okay, then I think now we will close the chapter by today.
Thank you so
So,
much.
okay. So
Okay.
that's the end of the session. Thank you. See you all.